I was elected as the president of the panchayat. The petitioner.
Panchayat is not here. Panchayat is bench 5.
Made your lordship. Lordship, in item number 12, lordship, I have filed affidavit, lordship. But after filing the affidavit, I came to know, lordship, some pages of the inquiry report is missing. So, lordship, I have prepared an additional affidavit to bring the complete inquiry report. I'm so deeply obliged, my lord.
That day I passed a judgment in Ajay Sharma's case. That case where you were there, no? Relating to some vehicle being given away.
Yes, yes, yes.
In fact, subsequently a Supreme Court judgment has come authored by Justice Bhuiyan
Lord,
exactly on that point.
my lord.
Yeah. Giving
That
it that there is no requirement of payment if it is just followed to that.
Eight
But-
form very good.
Yeah.
I can know
Obliged.
12 also I am appearing petitioner side, your lordship. That may be fixed, your lordship.
Which one?
12. I have mentioned
We'll see when the matter is.
that may be fixed, your lordship.
We have lordship, I can take up this matter. Already have fixed matter too, my lord.
Yes.
I have to prepare.
Obliged.
I lordship, I will follow this.
May I please also. I beg to mention item number 27. This court on earlier occasions, pleased to pass order for take the pending writ petition along with this contempt petition, but this writ petition was not tagged. But let the matter will come next week.
27.
27.
That matter has not been taken. Why?
But
That order show it, ask them to bring it by way of production list.
that's fine.
May I please your lordship? Lordship, I beg to mention item number 20 to kindly pass over for the day, lordship, as my senior is out of station. And an adjournment slip is also circulated as well.
What a good matter.
Matter relating,
2023. It's a very long, old pending matter.
lordship, kindly pass over for the.
No. We'll see when the matter is. You'll be lucky enough the matter doesn't reach.
Privilege.
My pleasure, Lordship. I beg to mention for listing of a review petition, Lordship. Lordship directed us to file a mutation appeal before the Deputy Commissioner, Borpeta. When we went there for filing the appeal, the entire records were changed, Lordship, during the pendency of the petition. And we came to know once when we applied for the
What do you want?
Lordship, because your Lordship has directed, fixed a time frame for filing the appeal. And when we went there within that time frame, the entire mutation records were changed. Now
It's okay, but have you filed the appeal or not?
we cannot file it because the mutation numbers, they cease to exist, Lord.
You filed the appeal. How is it? As per the direction of the court, you filed the appeal. We'll look into it later on. What do you want now?
Lordship, review of that particular order, Lordship.
No review business. You file a review, we'll consider it when the matter reaches after vacation.
Lordship.
But in the meantime, if it gets delayed, that is your lookout. But this is your problem. You should have filed it. We'll see what happens if it is not done that manner.
Lordship.
Anyways, you have filed a review.
Yes, Lordship.
Okay, file it. Who has asked you not to file? You are at liberty to
But I'm
file.
praying for listing of that matter because
Okay.
we filed it in the month
We'll
of
have
August.
it listed immediately after vacation on
Lordship.
27.
Any day after vacation, Lordship.
Okay, we'll have it on 3rd of November.
Lordship, we filed it on August, 2nd of August, Lordship.
If it has not listed, go before the registry. Review, it will come up in the list if you have, there is no
Not-
defect.
not-
No.
Alright.
Mr. Das, that day, yes, Mr. B. Chaudhary as well as Mr. B. Gogoi. That day after I delivered the judgment in the court for Rafiqul Islam, I found that when I was looking into the judgment in Rainbow and BSNL, because those are the two judgments which are actually applicable here. There, the question of the Article 366(29)(a), B is in question out there. For that, you need some transfer of property by way of transfer. No, forget, apart from the tender clauses, from the tender as well as the work order which has been given, There's no transfer of property. And as there's no transfer, it's purely a case of supply. For that, it may come under the Finance Act 1994, but under no circumstances the state can have a VAT. So accordingly, I'll modify that order to that effect.
That was my inference from the text.
That is what he has submitted.
From the contract and all, we inferred that the actual impact. Because we'll have to go by the now KP Mojika and again
Mojika is in respect to D. Mojika is different, where there is a vehicle being taken. Vehicle has been taken on lease. But whether the main control of the vehicle has been given or not, that is another aspect. Here, it is not the question of a tractor being taken on lease. It is a case where these people have been directed or given the tender for the purpose of carrying out a particular work. And the work does not involve even a brick being used or anything. It is just stealing. When it is a case of just stealing, it's a service. And if it is a service, the question of VAT would not come in. So the only question it may be a case of service. That's a different aspect which we are not concerned. So therefore, the state would have no jurisdiction in this regard. So we'll change that order in that.
Yes.
That is what.
Item 17, state pen 30 AM, part heart.
May I please, Your Lordship?
Yes, madam. Yes.
May I please, Your Lordship? Lordship, here the impugned order, my Lordship, it starts from 121. The relevant portion is 123, my Lordship. Here, my lord, the petitioner, while was working as Miss Case Assistant and Execution Assistant in the court of Munsif number 1, Kasar, my lordship. Record I said, no?
But you have stated in your written statement or all the proceeding that you had no idea about the stay order.
My lordship, yes, because my lordship, in this, the petition, while
Let's see your WS.
my lordship. Page number 4. My lordship, at page, annexure 12, page 84, my lordship. Okay. Page 93, my lordship. Page 93. Mm. Mm. Mm.
Madam, have you made a list of dates of this?
No,
They're
my
very
lord.
complicated dates.
My lord, should I prepare one, my lordship? If my lord, if I have not prepared, if my lordship asks.
But Mr. Das, one thing, whatever may be, this is too harsh. What is the punishment given?
My lordship, in under, no, my lordship,
There are two
two
punishments.
punishment under one subhead, my lordship.
Ah.
Two punishment. One was, my lordship, minor punishment and another major punishment. One punishment is reduced to lower scale, time scale of pay, my lordship. And the other major with further direction, he will not earn increment of pay during such period and on expiry of the period, the reduction will not have the effect of postponing his future entity. This is all as by the punishment also, it is under one head, my lordship, two punishments, one major and one minor.
That is not permissible.
That is also not permissible, my
Is
lord.
permissible?
No, my,
It is permissible.
no,
Minor penalty can be imposed.
no,
But-
major and minor.
So where is the,
In one head,
yes,
in one offense,
yes, it
can
is
you
connected to the first one,
Page
basic
one
pay,
twenty-three, my lord.
basic pay of rupees 10,570 to basic pay 7,930 for a period of 3 years with a.
accordingly under suspension is reduced
further
to
direction.
lower scale of pay of so and so for a period of 3 years with a
Yes.
from a month. Lower scale of pay.
Yes.
With a further
reduction of pay.
direction that he will not earn any increment of pay during the such period and on expiry, the reduction will have the effect of.
Postponing the.
So this is one and it is one,
no.
it is
It's
only
one.
one.
No, my lordship, withholding of increment of promotion, my lord, withholding of increment, my lordship, that is minor penalty.
Madam, that is not the question because here is a case,
Yes, lordship.
you have been, this is a major punishment which has been given, whereby you have been reduced in rank.
That is major, and the another is minor, my lordship, withholding of increment.
No. It is the moment you are reduced in rank, obviously the increment will, there cannot be an increment to that effect.
Yes, my lordship.
You will
but
not
as per
earn
say-
increment for pay during the said period. Increment for pay, how do you stop? You are reducing him. You see, the increment is to be given every 6 monthly
1 year.
or 1 year.
Yes.
This is being given irrespective of whether he is in that post or reduced post.
Yes.
So you have stopped both.
No, it is by virtue of a penalty, but it's not that both are separate. There is,
Understood. Just for example, a person who is an AJ, he is being reduced into rank of
yes, this is reduction of pay.
Understood.
Understood, yes.
A J is reduced in the rank of JA and he will be getting the pay of JA for 3 years or whatever may be. Reduced to the lower time scale of pay
Yes, ma'am.
from BP basic pay of so and so to so and so. That means he is given reduced scale.
Yes. With
Okay.
With effect from 21/11/2011, his basic pay will be 7,930.
390. So thereby he is being given to a person who is getting a lower rate of pay. So at that point of time, he will get that amount and accordingly all other computations will be taken in that regard.
Yes.
But he's then also on 7930, he's entitled to an increment. every yearly? That you have done it.
That, this is by virtue of a penalty. My lord, what I am trying to convey to your lordship is that, my lord, this stoppage of increment is also a penalty, and there is no bar. My friend
no,
has not been-
understood.
Yes.
So therefore, there are two
It's
forms
not
of
that-
penalties.
It's not that if major penalty proceeding has been initiated, only major penalty has to be.
No. If major penalty initiated, you give major or you can give minor.
Yes.
Minor, you cannot give major.
Yes.
But her contention is not that. Her contention is you have given a major as well as a minor.
There is no bar.
Show me that
Yes, my lord, I'll place me.
there can be two penalties imposed
Yes, my lord, major minor can be.
in respect to the same offense.
Yes. Because we are concerned with the penalty. Look, penalty has been segregated in the rule major, minor. But ultimately, all in rule 7 are penalties. So all the, my lord, provided in rule 7 are penalties.
Understood.
So the disciplinary authority, to my understanding, has got the
So
liberty to.
are you saying from 7.1 to 7.7
Basically, all are
upper
penalties.
in a case, in a particular case, a disciplinary authority can impose all 1 to 7 in one case in respect to the same on one cause?
No, all 1 to 7, my lord, if a dismissal from service has been imposed.
He can be
there is-
he can
there
be
is no-
given censure. He can be given some form of penalty.
to be-
One,
it has
number
to be
two,
realistic.
number 3, and number 4, number 5, till number 10. He can be given.
I'm not saying that. What I'm saying.
This is what has been happened.
No, it's.
Yes, there are two forms of penalties out here. The major penalty is his scale of pay is being reduced. That is one. The second penalty is you have stopped his increment on that reduced scale.
For that period.
Yes. So there are two penalties.
So the question I'll have to address your lordship is that whether minor measure both can be imposed in one stroke. My lord.
One
I can address your lordship.
2 o'clock?
My lordship, in humble request, my lordship, I have to leave out of station as tomorrow matter is fixed at 0 court, my lordship. So my lordship, if not taking today, my lordship, any other day, my lordship, humble.
You have shown urgency. It's not me.
I have to leave by 2, my lordship, kindly consider. Tomorrow at 0, my lordship, because there is no holiday out there, I have inquired, because tomorrow it's holiday out here. My lordship, may kindly consider.
This court, upon hearing the counsel, will stop. The learned counsel appearing on behalf of the petitioner submits that the order passed by the disciplinary authority is perverse, taking into account that the disciplinary authority had assumed that the petitioner who was the delinquent had stated that he was aware of the stay order. The learned counsel, drawing the attention of the statement of defense, submits that amid such materials, that the contents thereof would show otherwise. The learned counsel, appearing on behalf of the petitioner, further submitted that the order dated 4/6/2013 is required also to be interfered with on the ground that two penalties have been imposed upon the petitioner on the same cause. And as such, elaborating her submission, the learned counsel submitted that the perusal of the impugned order would show that on one hand, the petitioner, the punishment of reduction in the scale of pay have been imposed, which is a major penalty. And at the same time, a minor penalty has also been imposed by debarring the petitioner to be entitled to the increment during that period. Next. The learned counsel appearing on behalf of the petitioner further submitted that even assuming for argument's sake that there was some mistake committed by the petitioner, the punishment so imposed was grossly disproportionate to what was proved during the disciplinary proceedings. The learned counsel therefore submitted that this is a fit case for interference. It is also submitted during the course of the hearing that on the basis of the punishment which have been imposed upon the petitioner by the impugned order dated 4/6/2013, the state's punishment is sought to be taken as a precedent by the disciplinary authority, by the appellate authority in another proceedings, and resulting in which the and as such submits that a matter requires an early disposal or passing of certain interim directions. This court inquired with Mr. H.K. Das, the learned counsel appearing on behalf of the Guwahati High Court, as to whether the disciplinary proceeding, the authority could at the same stroke impose both a major penalty and a minor penalty on the same cause of action in respect to one offense. The learned counsel submits that it is permissible, but he seeks for some time to produce precedents. Taking into account the above, this court fixes this matter again on 6th of November 2025. In the meantime, this court directs that the order dated 4/6/2013 shall not be taken as a precedent by any authority while dealing with any authority shall not be taken as a precedent in respect to the appeal which is presently pending before the Secretary Judicial Department of the Government of Assam. I go to man.
Will it, the last portion of your lawsuit's order, because that appeal is pending. So the petitioner has all the right to challenge the decision that will come.
This
after
should
the-
not be taken as a precedent because this court is adjudicating it. Otherwise, show me the judgment.
No, not
Show
my,
me the judgment.
in fact, there is no material perhaps before your lordship, subject to your lordship says that in the earlier, the subsequent proceeding, this has been, this charge has been taken note of or something like.
It is her submission which was made on the last occasion, and that is the reason why I have fixed it at today at the top of the list?
Yes, my lordship. Early date
The
Not
appeal will
early
be
date
pending.
or what, fine. It's not about early date, fine, my lord. If your lordship thinks it proper, my lord, fine.
My lordship, should I give the list of dates also in this case?
You should.
My lordship, I will give on next day of next.
Suppose the list item one, what heard?
Yes, what happened?
Attempt was made, an offer came from them
Hmm,
for a out of court settlement.
hmm.
Lord, since there is, my friend has said, your lordship will, for the time being, may refer the matter to the mediation of the High Court. So. And above, we should.
Good.
Let both the parties sit before the mediation once.
Otherwise, my instruction is offer came, but they want present market value. That is the reason it could not be settled. Present market rate will be very low. We are agreeable to pay more. And we have said that we'll pay more, but then they want present market value. That was the difficult. Anyway, my lord. Leave it to
Let the parties.
Both the
sit.
parties agree that a chance can be taken before the mediation center of the Guwahati High Court for an amicable settlement.
Dollar will have on merit.
So taking into account the above,
It had a fixed file of-
this court directs the registry to place the incident matter before the mediator, before the mediation of the Guwahati High Court. Post-
6th of November.
I can't fix it. The
They will fix, they will. intimate.
mediator shall duly intimate both the parties and thereupon shall submit a report within 120 days from today. 120 days will be 6 months,
January. it will be-
4 months, huh?
4 months.
120 days from today. Full stop. Taking into account that the matter has been sent for mediation, this court releases it from party.
God bless you.
For motion item two,
Could be kept as a part of the law. 3 months time.
I'll
4
forget.
months.
I can't keep it quarter
More than
long.
all.
Yes. Mr.
Yes,
H.
President.
Taluka,
My lord,
what is
here the
this?
petitioner is a grade one stenographer lordship, retired grade one stenographer lordship. Petitioner is a retired grade one stenographer lordship under the principal judge lordship.
Grade 1 stenographer.
Lordship,
And what do you want?
she's agreed with rejection of 4 numbers of houses relating to the LTC bill lordship. Claim amount is only lordship 6,400 lordship.
What?
Lordship,
Horse
impugn-
riding you want for what?
lordship, page number 44 lordship.
Huh?
Impugn letter lordship.
Where
My
is that horse riding?
horse riding lordship from Vaishnu Devi.
And you want it for what?
Katra to
purpose?
Mata Vishnu Devi lordship.
What do you want it for?
Lordship.
For
this-
LTC?
Lordship, LTC lordship. Lordship, four houses were rejected lordship. On the count that signatures were not taken on the revenue.
First of all, horse riding would not come within the ambit.
Lordship, there are only 3 ways, lordship.
Go, you should have gone by holy helicopter. And if you had such a pious obligation, you should have walked.
Lordship, there are only 3 ways, lordship, and it is the cheapest one, lordship.
Where?
Houses are at page, lordship, 30,
Uh,
30, 31, 32, 33, lordship. Amounting to rupees 600, lordship.
31?
30, 31, 32, 33, lordship. These houses are rejected, lordship.
Obviously, it will be rejected.
And
It will be rejected. Now, this is no money receipt. First. Secondly, what is the rate?
rate is, lordship, so far.
What is the rate of the horse?
1250 rupees, lordship. Rate,
Where do you show?
lordship.
Show the rate. of going to,
Lordship, page Lordship 51,
huh?
page 51 Lordship. Page 51.
51.
It 1,250 per person.
Where? No. This rate cannot happen.
Lordship.
This is not a horse ride. This is somebody writing it in AI, Google AI, and you put it. Base your decision on a proper thing. There's a big signboard there. Why you are not putting it there? There's a signboard, there's a fixed rates.
Fixed rate is 1,250 rupees Lordship. 1,250 rupees.
Huh?
It is genuine Lordship. 1,250 rupees Lordship.
You went there.
Lordship, I know that Lordship.
You know that.
Know that Lordship.
So what should I do? I dismiss it.
Lordship, one justification was submitted, which is at page 45 Lordship. That may be disposed of Lordship.
Absolutely no. This type of cases should not come. You can't go by horse. Tomorrow, if you feel like going to Kedarnath by walking, by Kedarnath by P2, then you could have very well taken that palki also,
Lordship.
which should have been around 4,500. Why haven't you taken that?
This one is the cheapest one Lordship.
This is not the cheapest one. Walking is the cheapest.
Lordship.
And you are not entitled to
The
this.
petitioner is a 60 years old person Lordship.
Who?
The petitioner is a 60 years.
How many persons went?
Husband and the petitioner. 2 persons Lordship.
Then?
Both are retired Lordship. Retired person Lordship.
After retirement, you took LTC.
Lordship, at the verge of retirement Lordship. Before 1 month of retirement Lordship.
Then? What is the rejection?
Rejection is at page 44 Lordship. After that, I submitted my clarification. Lordship.
But remaining amount has been given or not?
Given Lordship.
Only these two.
Only this. Only
So you are fighting this case for how much amount?
Lordship 6,000.
12,150 into 4. Isn't it?
Lordship.
For 5,000 rupees. You must have spent more than that for the purpose of this.
Lordship.
Isn't it? Is it done by the legal services authority? No.
No Lordship.
Then?
Petitioner is a known person to me, Lordship. She approached me, Lordship.
Good. Yes, what do you say? No, this, obviously he can't get this, but the fact remains. Yes, who is appearing for the High Court? Okay, what do you say on this? What do you say? So that means you otherwise admit that he is entitled to the horse riding expenses. No, I'm asking you this. Forget about the house. This, he can very well get it from the Vaishnav Devi website. They have the horse,
Lordship.
not from Google.
Lordship.
I'll give him that permission. But the question is, I'm asking you, is he entitled to the horse riding thing? Means if you are not going on to a question that vouchers is not, means otherwise you accept that he's entitled to. Where's your affidavit? So you must be having a copy.
Yes.
And Mr. Counsel, there is another big problem you have. If you take, actually you have to pay that amount there. You can't take the horse from the road. I think you have never been there. If you have been there, or you must have always, with your pious thing, you just walked out. But if you go there, first you have to pay there. There's a counter.
Chip.
You can't just go there and take a horse on the road. No. Everybody, every pitu, every palki, everything has they have a particular fixed, they have a turn, and they get as per the number. It's like a prepaid taxi.
Yes, Lordship.
So then why didn't you get that? You should have got that receipt.
Lordship.
And this is a receipt issued by some JK
Authority.
Tourism or something. You should have got that. How can you get this on the basis of this? That case
Lordship.
can't help you. I had all sympathy for you, but I
Lordship.
can't.
Lordship, may I reconsider the same by the
No, they
authority?
cannot. With this affidavit being given,
Lordship.
they don't deny that you are entitled to. But the fact that that document cannot be given, and you also know, I also know,
Lordship.
these people doesn't know how to read or write anything.
Lordship.
Those persons.
Lordship.
So the signature is another thing. You should have got it from there.
Lordship.
Hello. Hello. Heard Mr. H. Talukdar, the learned counsel, appearing on behalf of the petitioner. Mr. Who is appearing for the High Court? You. What's your name? A. Burwa appears on behalf of the respondent numbers. Mr. B. Gogoi appears on behalf of the respondent numbers 1, 2, and 5. And Mr. So-and-so appears for the respondent number 4, and Mr. So-and-so appears for the respondent number 3. The petitioner herein, who is a stenographer grade 1, working in the, who was a stenographer grade 1. Prior to her retirement, she retired, no?
Retired, now retired, Lordship.
Prior to her retirement, took a trip to the temple of Mata Vaishno Devi by New Delhi, Jammu and Katra. The dispute in the instant proceeding is limited to not reimbursing the cost which the petitioner as well as her husband, which the petitioner paid for herself as well as her husband, while traveling the distance from Katra to the temple of Mata Vaishno Devi with the help of horses. Full stop. The claim of the petitioner have been rejected on the ground that the money receipts so enclosed at page 30 to 33 of the writ petition do not appear to be genuine. This court further takes note of the affidavit which have been filed by the respondent, number 3, wherein the reasons have been given at paragraph number 4 as to why the petitioners claim in respect to expenses incurred for taking horses for traveling the distance from Katra to Vaishnav Devi, temple of Mata Vaishnav Devi, and return were refused. Paragraph 4 of the said affidavit being relevant is reproduced hereinunder. From the grounds and reasons so assigned, as well as also taking into account the documents which have been enclosed by the petitioner basing her claim, it is the opinion of this court that the rejection of the petitioner's claim in respect to the reimbursement of the amount towards riding the horses from Katra to the temple of Mata Vaishnav Devi and return was justified. Accordingly, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed. Take on the paragraph 55.
Obliged Lordship.
Supplementary item 21.
What is this?
Well, my-
Motion?
Yes. On the last occasion, my learned friend was asked to obtain instruction why my electricity connection has been disconnected.
Has been disconnected?
Yes.
You have got the connection back?
No.
Why?
My lord, it was at the initiation of response number 4. Actually, what happened in 2014, I had an agreement for sale with the husband of response number 4. And I have paid 13.5 lakh out of total consideration of 18 lakh. I was put in possession. But before the sale deed could be executed, the person died in a road accident. Now the wife is not willing to sell the property, for which I am contemplating to go for civil suit. And on the application of the respondent number 4, my electricity connection has been disconnected. So I am before your lordship.
So what is your judgment in your favor?
One.
Dilip dead.
Dilip versus one. Yes.
Dilip dead,
They I have not, this one.
isn't it?
Dilip dead, yes.
Dilip dead.
One is this one, my lord.
Dilip dead.
Dilip death, yes, sir. That's being relied.
So, what do you say, Mr.?
Lordship, requirement in belief that is that the person should be in occupation of the premise.
He's not in occupation.
I mean, but the field inspection was conducted. Lordship, would like to peruse the photograph that was taken yesterday. It was, I'm instructed that it was taken yesterday, and the instructions are also there.
Oh. Where will they go? They must have locked it from outside, na? Now you're not staying with lamp and all.
To and fro.
But they have curtains there inside.
Yes, otherwise your Lordship, your instructions are also somewhat shocking, what they have said. I'm not exactly.
Any matter post visited his
I have just received.
office to inquiry. regarding new service connection and following which he was requested to submit all necessary documents for but after doing the effort. they have to be taken, they understand. So it was disconnected on 14/11/2023,
Yes.
and you approached this court in 2025.
So thereafter, I wrote a letter to them. For,
No, no,
they
you have approached this court in 2025.
yes. In
And
between,
now
they have,
now you are saying that urgency.
I'm not saying urgency, but this
So
have brought
why
it.
should we disturb them? We will look into it. First, issue notice.
Now, in 2025, my lord.
No,
Yeah, on the
2025.
basis
no,
of my
heaven
application
to the
that they
fallen.
say, Lordship may kindly look.
No, first of all, 2023, it has been disconnected. And you have come before this court in 2025. Don't you think that this court should issue notice first to them? And ask even this lady, Malavika Nath Roy, about what is the aspect?
Lordship
I would
may-
have understood if it was done during this month, immediately I'll ask them to do it. But would it be fair on the part when it has been disconnected on 14/11/2023 and the next morning you jump out here after 2 years and say that no, tomorrow we
So
need
I
disconnect.
can explain, my lord, what happened, my lord. In 2023, I filed an application. They restored my connection. Then again on her application, again on within a 1 month, they
Show
have,
me where you mentioned.
I have mentioned.
And then also you have not filed a suit.
Suit I am contemplating, my lord.
Huh?
We are we are going to file, my lord.
When did the disconnection happen?
2023.
Well, time is running out. If you don't get the specific performance of the contract, then where have you mentioned?
To the paragraph, my lord. Paragraph 11.
It is specifically stated here that immediately thereafter, the PDCL reconnected the electricity power supplied to the lawfully occupied premises in the last week of September, but again in the first week of October, the power electricity was disconnected.
Yes.
Approached the PDCL to inquire about the reason for disconnection. He was informed the same was done at the application complaint of the petitioner visited the office of the respondent numerous occasions regulating its so-and-so. But the respondent number so-and-so considered the application petitioner's application
Only on
only
16.
on IMAR. See,
Yes. Only on 16/8/2025.
these are serious allegations which have to be refuted. We'll hear it after vacations in a cool mind. Issue notice. Returnable on 27th of October 2025. Mr. KP Pathak, the learned counsel, standing counsel of the APDCL accepts notice on behalf of the respondent numbers 1, 2, and 3. As regards the respondent number 4, the petitioner is directed to take steps by way of speed post. This court further directs the petitioner is or further grants the liberty to the petitioner to effect service upon the respondent number 4 by way of trustee routed through the registry of this court and file an affidavit of service on or before the next date. It is the case of the petitioner that the petitioner had entered into an agreement for sale with the husband of the respondent number 4 on 9/12/2014 for purchase of the house, purchase of the land as well as the RCC building standing thereupon. And out of that, out of the total consideration of 18 lakhs, 13 lakhs 50,000 have been paid. However, unfortunately, the husband of the respondent number 4 expired on March 2019. It is the further case of the petitioner that the petitioner have thereupon continued. Petitioner who was handed over the possession thereupon continued to remain in possession of the suit over the RCC building. And in the month of October 2000, in the month of October 2023, the electricity supply was disconnected. The petitioner, in the meantime, submitted and immediately thereupon had submitted an application which was not considered, and which was not considered till 16/8/2025. And it is under such circumstances the petitioner has approached this court. Full stop. The petitioner herein, though, claims full stop. It is relevant to take note of when the instant writ petition was moved on 3/9/2025. This court directed the Standing Council of the APDCL to obtain instructions. Mr. K.P. Pathak, appearing on behalf of the respondent numbers 1, 2, and 3, submitted that placed before this court an instruction dated 11/9/2025. From the instruction, it appears that the electricity meter still continues in the name of Surajit Roy. Full stop. And it was disconnected on 14/11/2023. Therefore, the said instruction appears to be contrary to the very stand of the petitioner that in the first week of October 2023 that the electricity connection was disconnected. It is also mentioned that on 16/8/2025 that the petitioner had visited the office to inquire about the service connection, and thereupon the petitioner was asked to submit all necessary documents as per the terms and conditions of the APDCL. The petitioner thereupon submitted certain documents, but it was found that one of such documents which have been submitted had the signature of the present subdivisional engineer Dhekiajuli Electrical Subdivision. Present incumbent subdivisional engineer Dhekiajuli Subdivision, which would not have been possible taking into account that the said incumbent joined only on 28/9/2024, whereas the signature was shown to have been put on 28/7/2023. In addition to that, the instructions further show that a personnel of the APDCL authorities have visited the site and found the entire building under lock and the entire property under a lock. property having is in a locked condition from locked condition. Found the entire property in a dilapidated and locked condition. Full stop. Taking into account that they said instructions are kept on record and marked with the letter X and Y. Full stop. Taking into account that serious allegations have been made and there appears to be certain dispute as to whether the petitioner actually is in possession of the suit property or of the building, this court would not like to pass any order without hearing the respondent number 4, as well as taking on record the stand of the respondent's epidician. So accordingly, this court therefore directs the respondent epidicial to file an affidavit on or before the next date.
Of like,
Item 22, permission.
my lord, the matter relates to supply of the uniforms to the schools, my lord.
Huh?
And
Uniform?
this uniform to the LP and ME schools, lordship, the students. Lordship, kindly have a look first the guide, this notice, my lord. And lordship, kindly have a look page 60, lordship. Annexure H.
Only 2 respondents.
Only 2 respondents. This director is the person's matter to
Commissioner and Secretary to the Government of Assam Education Elementary Department. Is there any something like that?
Elementary has no role, Lordship. Just because they are government, that is why they have been made party, Lordship. Otherwise, these tenders are to be issued by the respective schools only, not even by the SSA, Lordship. We only set the guidelines. If
Here-
Lordship,
And where is the school?
it will
The
be around.
school, where is the school? Not a
School-
party.
School is not a party. So
my lord,
against,
here only.
against which tender issued by which school he is going to participate, this is not here.
No, my lord, here only.
That is one, Lordship. And if Lordship comes to page 67, Lordship.
But Mr. Naik, tell me whether there is a Commissioner and Secretary to the Government of Assam Education Elementary Department.
They have no role, Lordship.
Is there anything like that? I
Commissioner,
think now it is the School Education Department.
yes, school education department, that is also.
There might be Director of Elementary Education, Director of Secondary
Secondary
Education.
education.
But do you have a department for elementary education separately
Department
outside
of-
the school education?
Department of Schooling.
So as I know, it is a department of the school education. But where do you find this official? In respond number 1,
One is, yes, Lordship.
fictitious?
Yes. That is one. And secondly, Lordship, only mission director is the party. Mission director has only set the guidelines. Lordship. Tenders are not going to be issued by the SSA.
Now where is the
Tenders
tender?
If Lordship comes to the guideline, Lordship,
Okay, let Mr. I have enough. Before he started, I have grilled him. Now let Mr. Chetri say something.
Lord. This is a letter, my lord, that is annexure H page 60, lordship.
Basically,
Page 60, lordship.
yes.
The letter was written by the director, my lord, mission director to the district mission coordinator and all district elementary education officers, my lord, for guidelines for free school uniforms for the student of class 1 to class 8 of government, provincialized LP and LP, UP and composite schools, lordship. And now, thereafter, my lord, on the basis of this letter, the guideline has been issued at page 62, lordship.
No, the guideline has been issued. By this letter, they were asked to circulate.
Yes. It was the notice just issued and
This is the guideline.
yeah, now guideline, lordship. Guideline, the 8/8/2025, whereby it has been said, my lord, lordship will find the relevant portion, my lord. Uh, The relevant portion, I'm coming page 73, Lordship.
But before that, come to page 62.
Lordship.
Are you challenging the guidelines?
No, we are not challenging, my lord.
Okay. Now, how do you take care of B?
My lord, here, in view of these guidelines, we have been debarred from participating.
No. Therefore, are you challenging the guidelines?
No.
I'm asking you, therefore, I'm asking you, are you challenging the guideline? Because the procurement of the uniform will be done by the SMC or SMDC of the school by following the procedure. So somebody has to issue, the procurement will be done by the school managing committee or school managing, what is the
My lord, yes, my lord, that,
district committee?
my lord, that part,
Development
yes,
committee.
that part, Lordship,
School
will,
management and
my
development.
lord, there is a portal setu, my lord. First portal, in the portal setu, the persons, the vendors has to apply in the portal setu. Once it is registered, then only they will go to the SMDC or SMC, my lord, for participating in the tender. Without registering in the portal setu of the government, my lord, that cannot be done.
So
And
you
we
are
have-
now debarred from.
Yeah, exactly. We have been debarred from registering in the portal setu
By whom?
by the mission director, my lord.
Show me that.
My lord, lordship, kindly see page 72, my lord. It starts from 72.
Hmm.
Last, my lord, committees for evaluation and monitoring. And one role of head teacher, so and so. Now 73 is important, my lord. Page 73.
Yeah.
C. Only those vendors who are registered in Shiksha Setu will be allowed to participate in the tendering process. D. The vendors who are blacklisted due to supply of substandard quality of uniform during the year 2023-24 and 24-25 shall not be considered to participate in the tendering process and also in the quotation process. Malet, and timeline to be fixed so that the work orders issued within 31st August 2025 in case of short quotation. And that is done, my lord. Now we are on within 15 September 2025 in case of open tender process. We are on this open tender process, my lord, which is 1 lakh above, my lord, and 2 lakhs below, my lord. And the SMDC, SMDC will ensure the quality uniforms as per the specification, color and sizes of the uniform are supplied.
No, we are not concerned with those.
Lordship.
So
And-
you are only on C and D.
Lordship. And where
So you are not being able to register.
registered?
Why?
Because, my lord, I have supplied the about 36 schools. Last time I have supplied. In one school, I have found the substandard quality. And that when complaint has come from the SMDC, my lord, that has been meted out. That has been replaced. That has been replaced, and accordingly, I got the bill. Everything, my lord, because managing unless and
So
until
you are not blacklisted.
no. I-
But why you are not able to register?
No, now is because I have done everything, but even then they have inserted in the list of the vendors that since your supply was found to be substandard, so you
Where,
are
where,
thereby
where?
blacklisted.
Which letter?
Lordship, kindly have a look this page 56, Lordship. Page
Read.
56, the list. 57, my lord, from 57, my lord.
Ah.
57, Chirang. Kuntu?
Shila.
Oh,
What is your name?
Soraidev, my lord.
Excellent.
Soraidev Shraddha Enterprise.
Right. Where page?
Page 56, Lordship.
Toraido.
Soraidev. Last, Soraidev.
You are not there.
I'm last, my lord. Next, 57, Sarada Enterprise.
This is filed by some excellent.
No, 4 petitioners are there, my lord.
Now, where's excellent?
Excellent. Next, Lordship will find.
And
page 58.
all the 4 have supplied substandard materials and replaced it.
Replaced.
All 4.
All 4. Only one school, my lord. They have the 35 schools, somebody is 40 schools. Only one school they have found.
Party is not all these petitioners having not separate causes of action?
That part, my lord, bond is, since the list is one, my lord. that
No,
is-
list cannot be one because everybody's thing is blacklisting separate.
The court fee has been paid as per your lordship's.
No. This is not a cause of action question. It is a question of there might be conflict between 3 and 4 because you are all joint suppliers. You may, 3 may say that I don't like 4 being given so much of quantity. How do you take care of that? Wouldn't it go conflict? Or isn't it a case of cartelization? Cartelization you oppose, no? Does the state oppose cartelization?
That is there in the Procurement Act also.
Yes. Then you'll be in more trouble.
My lord,
However, I give some leeways not in that. When the counsel for the petitioner waives out 3, takes out 3 and only has 1, and give you the liberty for the 3 to file separate petitions. That I can do. But I cannot allow 4 to go together because this goes against, in fact, that would be a wrong thing which you are doing it. That day also somebody did it, no? Oh, wait here. In another case where pertaining to a jail contract, the petitioner had 3 persons. I said the 2 has withdrawn, 1 was there, but with 1 only the thing got resolved. So nothing happened. But I didn't allow 4 because it will amount to cartelization.
Following that principle, Lordship, here, even if 1 is allowed, others have to file.
Yeah, they will have to go. Anyways, now tell me.
now,
Let us go by excellent. Where is excellent?
uh, excellent lordship will find
Page 58.
page 58, lordship,
58.
this Kamrup Metro, my lord. The serial number 13, lordship.
Oh, there are 2 only.
There are 2, Kamrup Metro.
Whose lab test reports are not as per requirement in last year as per test report of the state level. So this is like blacklisting.
Blacklisted.
Then
But everything was done, my lord. I do not know why it has been done, my lord. And now, my lord,
or these are all these people who have been blacklisted.
blacklisted.
Okay.
Already they have approached before this honorable court, and this honorable court protected their interest, my lord. Lordship.
How
Lordship will find at page
somebody else has protected.
uh,
5165, 68.
5168 annexer L, lordship. This
Oh, there are kind judges. You missed out your chance. Having considered the submission of the learned counsel for the party on perusal which reflect to the human having supplied substance in the last 2 years and that too who have been blacklisted due to substance demand shall not be considered demand. In the time of the considered view that an interim order is called for and state review of the fact of the debarring them from participating in
there was no notice, nothing else, my lord.
accordingly maintained and law. Means how, if this order is to be there, wouldn't that amount to stay of the process?
My lord, it's a tender process will be opened, my lord, on 15th of September, my lord.
Hmm.
That is why, if not these petitioners allowed to register in the this Setu portal, then he cannot participate in the tender process also, my lord.
But Mr. Nayak, same type of order has been passed by learned coordinate bench.
Lordship, if Lordship comes to page 72, Lordship. Page 72.
Yes.
If Lordship comes to the last 3 lines of the second paragraph, Lordship. However, at the same time, this is dated 21.
Supplied poor quality materials will remain blacklisted even
Will
if
remain
they are
blacklisted
having
even if they are having GST registration prior to.
Now, Lordship, the question is, rightly or wrongly, a decision has been taken, Lordship. They has been declared blacklisted. Now, without challenging this document, Lordship, can the issue of
But how do I take care of a coordinate bench passing and all? Yeah, yeah.
then then Lordship comes
If
to
I was the first person, Mr. Naik, I would not have allowed all these persons together. But now taking into account that a coordinate bench have passed for everybody,
yes,
it
I
will not be
understand.
proper. Then Mr. Chetri will just go outside and say that this court flagrantly violates Article 14.
But Lordship, that order was passed in the month of August itself.
No, 5-9.
5-9.
5-9 is Lordship not registration. In the second case, Lordship, registration has been given,
No,
but they were for some reason, the applicable judgment is at page 75, Lordship, where registration was not there. In the second case, they were allowed to register.
No, here also 5-9 also they are being allowed. It's the same case, and you had appeared out there. Really? That part. If I was the person, I may not have done it. But the fact that somebody else, you allow them to participate, but why are you not initiating this action? Because there is a categorical mention. of
My understanding is that by this letter dated at annex page 72, Lordship, we have already declared them blacklisted. All those names appeared in the list of substandard suppliers are blacklisted.
Where?
Page 72. Last three line of second paragraph, Lordship. However, at the same time, all firms who supplied poor quality material will remain blacklisted.
Page?
72, Lordship, Annex J.
72.
No, which clause?
Not clause, Lordship, it's a letter dated 21/8/2000.
That is not 72. That is another page. This is Annex J, page 92.
This is 92. নহয় হেৰি গৈছে
বেলেগ copy দিব।
নহয় number 2
Page 92, Lordship, second paragraph, last three line. However, at the same time, all firms who supply poor quality material will remain blacklisted even if there is so and so. So this declaration is there that you are blacklisted.
No, that's not listed. This is for GST. We have not been served any notice, nothing else.
You silence this, it is not under silence, Lordship.
No, nothing has been supplied to us.
I'm not that also, Lordship. If
No
Lordship comes
opportunity,
to
nothing,
the
no notice.
guidelines, Lordship.
Simply keeping in the file cannot be,
You have not silenced
put
it,
the
that is
right
what I'm
matter.
submitting.
But I think, Mr. Naik, that is a problem.
Yes, but if Lordship comes to the guideline,
If
Lordship.
you want this court to take up all the other matters and decide it separately on a final decision is okay, but
Yes.
I have to give them that.
But at this stage is different, Lordship. If Lordship comes to Annexure I, that is guideline dated 8/8/2025,
Yes.
page 82, Lordship. If Lordship comes to B, procurement procedure. First is procurement of uniform will be done by SMC, SMDCs. If Lordship comes to second, the procurement of uniform of value up to rupees 1 lakh shall be done by inviting short quotation notice. And second one is 1 to 20 by open tender, Lordship. But if Lordship comes to the timeline, Lordship,
Timeline.
yes, timeline is a F, Lordship. F to sub, timeline procedure.
Timeline, page 85.
Page 85, Lordship. The supply of school uniform must be completed within 31st/12/2025 without fail. The timeline supply uniform will not be compromised at any cost. Last date of supply of school uniform is 31/12/2025. Then if Lordship comes to page 67, yes. 18 years, date 2 years.
Page DD, 87.
Page 87, Lordship. Now,
Who
Lordship,
were blacklisted due to supplying of substandard uniform during so and so shall not be considered to participate in the tendering process.
one, this is not challenge, under challenge. E Lordship, that is important. Timeline to be fixed so that the work orders are issued within 31st of August 2025 in case of the short tender, short quotation, that is below 1 lakh, Lordship. But second one, within 15 September 2025 in case of open tender process. Today is 12, Lordship, 11. 11, Lordship. So bid has already been, we are going to issue work order before 15 September, by 15 September. Means bid has already been notified, Lordship. Now, when he will participate, when we will consider, and in that situation, whether it will be possible for us to issue work order prior to 15 September 2025 or not.
It is the petitioners, my lord. They will do it.
How do you register in the success?
In the other case, Lordship, court directed without registration, let them participate in the tender.
How is it possible? That is not possible. I have serious doubts.
That is my
But we are
case
going
also.
to find out from there. Because there is a particular module in which we are going to do it.
Lordship.
How by way of manually you can submit? Difficult.
Now they will enclose the court's order and participate in the tender.
How is it possible? Then it is subject to manipulation. With due respect.
Then basically that is there. One substance
But
list
Mr.
of,
Mr. Naik, you also have to understand the predicament of this law.
I understand, Lordship. That
The
is
court
why
having
that is
passed
why,
order. Because you see, first of all, more particularly, they have to be allowed to participate in the secret setu. Because if you don't do it, there might be somebody giving it manually. It cannot be done when you are doing it everything online.
but that is going to happen, Lordship, because of court's order, Lordship. What can I say?
But anyway,
So, but my only my concern is that this
but
timeline.
tell me, can't they upload it in the secret setu? I'm not going to pass that order. That I'm allowing them, but then also, can they be put in the secret setu? If it is done, then it is better. It can be done on that. Whether you consider, don't consider, that is a look, that is your call. But giving by hand is a very difficult.
But Successity is an online app, Lordship. There, Lordship, there is no provision of manually doing a registration, Lordship.
So they will.
So now the persons who have been allowed, Lordship, they are going to do this manually,
No,
Lordship.
is there a switch or a twitch by
Now,
which?
Lordship, if this person's names are there, Lordship, in the website. So as this 8/2/2025 notification is there, as they supplied substandard materials, they have been declared blacklisted. So their names will not be accepted by the portal law. Yeah. So that is why they are unable to register their names.
The hotel is being run and managed by people.
No, their names have already been fitted there, Lordship. Their names are there.
So this is fitted on the basis of that, and that be removed. I'm only on that, because
Yes.
what happens otherwise is you are giving rates. When you are asking rates on online mode is a different thing from giving on offline mode.
That was my submission also, Lordship, before that bench, Lordship. Let us issue them either, do something, let us find out some mechanism, Lordship, so that they can register as directed by the court. But court directly passed the order allowing them to participate.
Is a mechanism possible? Let's find out.
I have,
We'll take it up at 2. I'll pass the order. But I'll pass an order allow. But I think mechanism by allowing them to do it, you can do it. Allow it, because here is the question of rates. These rates, everybody has been putting. It is kept in particular silos out there in the online mode. It is not
these
open.
tenders will not be online, Lordship. These are manual only, open
Then-
tender. If Lordship comes to,
So they will submit, they only require a name to be inserted there.
without registration, they cannot submit
No,
their
the
bid.
registration is required, because otherwise later it will be.
That is
difficult
what, without registration number, no.
to allow them to register.
If Lordship comes to,
No, Mr. Naik, I think you can.
No, that one requirement is that documents to be asked from the vendors. Here, lordship, vendors details, Shiksha Setu registration.
But
number.
where is it mentioned that there cannot be registration? Wherein you see this particular clause only says, what? Timeline for procurement, the vendors who are blacklisted on a year shall not be considered. Shall not be considered for participation. But from getting them enlisted in the Shiksha Statute, how do you stop him?
Lots of vendors who were blacklisted due to supply of substandard quality of uniform during the year 2023-24 and 24-25 shall not be considered to participate in the tendering process and also in quotation process.
Quotation process. So the quotation is to be given by hand,
Yes,
as well as regards participation is also by hand.
there is a requirement of having the Shiksha Setu
So
registration.
that can be done. These guidelines has no business out there. Only thing is that he has to have a registration. You are stopping him from registering. How can you stop him from registering? Unless you blacklist him.
That order is there, Lordship, 8 to 2025. It is clearly there. Those who have supplied substandard materials will remain blacklisted.
You can blacklist him. You can pass any order for blacklisting him, thereby not allowing him to participate. But how can you stop him from registering? My question is this, can you stop him from registering? Because the guidelines do not say that they cannot be registered. The guideline only say that you cannot allow him to participate. So therefore, the question of participation can be, whether they would get or not, that will be subject to the outcome of the court's order. That's another aspect. But the main particular thing is whether can you stop him from registering?
So Lordship is saying that we cannot stop them from registering their name in the Shiksha Setu,
Yeah,
but we can
that's
still,
being mentioned.
but we can still stop them as they were declared blacklisted
Yes,
in
that
participating
you
in the
can
test.
do it. You
Yes.
can stop them from participation as per the guide. You can stop them from quotation as per the guide. But you cannot stop him from registering. You allow them in the registration.
In that situation, Lordship, either Lordship may take up this matter at two, I
Two.
can take the instruction whether they can be granted registration at this stage or not.
Yes,
Or Lordship may, as directions are already there in other cases. We are ready to give them provisional registration, Lordship,
no, where is the question of provisional registration?
if it is not possible in the app. Lordship.
Then you can give provisional registration. Because why? See, once you have a registration, then you can very well regulate. If you don't have a registration, it will have a serious consequence later on. I'm
Lot.
saying for the state, it will have a lot of consequences.
Yes, Lord. I
So you
understand.
have the registration because the guideline does not prohibit registration. What the guidelines prohibit is there cannot be a participation or in the tender process as well as in the quotation process.
In that situation, at two, Lordship, I will also place the
you get it.
guideline for registration, Lordship.
And-
If anything.
And the order which I am going to pass is that they will be allowed to participate. But if you intend to issue any work order, the same shall not be done till the next date, and I'll fix the date on 24th of September.
But our timeline is 15 September.
So-
Before 15 September, we have to issue the work order.
So then how do you do it for the other matters?
Others, Lordship, today is 11. Others, last one was on 9th, Lordship.
Understood,
And,
but you
the
see,
earlier
others
one
also
was a-
according in neighbor shall not be allowed to participate, made clear that the participation in here shall be subject to further orders. Means this order is also stayed. This is not disposed of.
Not disposed.
So therefore, this is also stayed. And this has been made after 4 weeks. So let me take up all these matters and finish it off on the next date before vacation. Then by you can complete and finish it off. This is good for you. Whether they are entitled or not, that is your lookout.
Lordship.
But otherwise, my only concern is you have a timeline to finish on 31/12/2025.
That is, I mean.
The
supply-
last date of submission of supply. So therefore, if there is a delay because of the court process, because here there is it cannot be given to them unless here. So if there is a delay in the process, it will have far-reaching consequences. And the only issue is whether any blacklisting is separately required to be done, or on the basis of this order, there will be a blacklisting. This is a short question, which if you want to, if the matter would have come up, you don't want to file an affidavit, I can give a decision right now and dispose it off. 2 o'clock?
2 o'clock.
May please, yeah.
Yes.
Also, in this matter, the last division of lordship wanted that we should decide that whether the rule can be challenged before the division bench. In this regard, we have instructions. Lordship, there is a representation pending. Lordship, that is at page number 56.
You have submitted a representation.
Lordship, and Lordship, in their affidavit also, Lordship, they had made an observation
We do one
that
thing.
it has been, Lordship,
Yesterday, the Chief Justice has formed a committee for amending the Guwahati High Court.
Guwahati High Court.
Rules of 1967. Let the representation be placed before that committee. I'll be sitting next week. And we can take it.
very well.
That
can-
Because there is another big issue out there.
Lord.
The senior stenographer is not, you are having in 2B only stenographers.
Lordship,
In 2B, you are having only the stenographers.
yes, Lord.
But what about the senior stenographers?
Lordship, as of now, Lord, we have been informed that.
Class 2 double A.
Huh?
Class 2 double A. Senior private secretary,
No, understood, but that is not a post for the assistant register.
feeder post,
Huh?
feeder post of assistant registrar.
And
2AA is not there.
Lordship,
In the rule, yes.
That is the
in
problem.
rule
no?
it is
That
not
is a
there.
big
That's the-
issue.
this
A
category-
person,
Seven is not.
a person who is a stenographer,
Yes, it's not part of rule 7.
who is
Seventh is not
gets
there.
the promotion to the post of senior stenographer.
Yes.
But that senior stenographer cannot become an assistant registrar, whereas a stenographer can. Isn't it? How do you take care of that anomaly?
There is an anomaly.
Huh?
Page number 19, Lordship, I
This
did
senior
the rule
private
7C.
secretary was created,
It has to go
thereafter.
from assistant registrar to A, Lordship.
Now, double A is what? Where is senior stenographer?
But 2A is not mentioned, Lordship, in the rule. That is
Senior stenographer is not there, na?
not there, Lord.
So therefore, the problem, yes, senior
But
private
it's-
secretary is there.
Rule as a topic.
Senior private secretary is a senior stenographer.
senior private secretary. Page number
Senior
private secretary.
65.
Senior private secretary is there. The senior private secretary who has a GP above everything, he or she has no right to be an assistant register. Maybe because of the same GP, it is same.
Lord,
Assistant
same-
register is same with senior stenographer,
Same.
grade pay.
Page number 20, Lordship, I've given a chart, Lordship. It shows that the grade pay is also the same, Lord.
Same.
Same as that of the assistant registrar.
In fact, there was a
And to the post of deputy registrar, who gets promoted?
uh,
Post of AR
A.
from 2A.
2A.
So that means not a person from senior stenographer, although grade pay is same.
In fact, there was a previous resolution. I have quoted that resolution in my affidavit. This will give some idea because there was a previous payer also made for encadrement of this senior private secretary to class 2A. Matter was placed before the committee and committee refused at that point of time.
That means they don't have a promotional avenue to become the deputy registrar,
In effect, that is
senior private secretary. They don't have a promotional avenue. Anyways, let the representation which has been submitted be placed before the
that will
committee
be correct. That
so that the committee takes a role on it.
even otherwise also, Mila, their prayer is to change the ratio between Mila, ministerial cadre and the stenographer cadre. Mila, otherwise also scope of judicial review is very limited, Mila, in that aspect to redetermine the ratio. So it should go before the committee, Mila. For a
No, now what he is saying out here that
he's praying that the ratio may be changed.
no,
4:1.
but what he is saying for 2C, I think it is no longer 27. 2C is not 27, it's much more.
Much more now.
You have the stamp reporter, you have the court officer, you have the protocol officer, you have the assistant librarian, system officer, all these are there.
By this time, it must
We
have
need to
increased.
consider the entire ministerial cadre when we consider 2C. Because it is the only, the below category post, this is the only avenue. While fixing the quota, that is our stand in the affidavit. It will be much more, Milord.
Now, in that, my judgment in Islam's case,
Yes,
the matter was taken up by, yesterday I was looking into that rule making, the rule committee.
yes, my
The
lord.
matter went to the division bench. The division bench has passed an order thereby placing it before the rule committee for making that correction.
Perhaps your lordship was not, lordship's order was not carried. for
No,
appeal.
but
The other,
no, other was there, but what has happened in the meantime, in that order passed by the Chief Justice and Justice Chaudhary
yes,
had given it out there that
in the.
as of now, this is the law out there, and therefore he has a right, being a court officer, which is same with AOJ, that court officer has a right to be considered for promotion has been stated in the division bench order. Which means, and only thing is that as regards the seniority, which is also duly protected in view of my judgment, has been mentioned. And further to that, it is also mentioned that let the rule making committee now remove that rider out.
In view of the Miller 2-member committee, yes,
Two and that, yeah, all these things
correct.
to remove that. So
Correct.
that has been given in that judgment. And now the matter is placed before the rule.
Yes.
So that is also to be taken again by this 67 rule.
Correct.
So that is what it is. So therefore, it is not only Mr. Bedala, these are the only 44 who are there. There are much more here.
Much more, maybe.
Because I think now, AOJ's cadre would be around 29, 30.
Yes, my lord.
Then you have the stamp reporter, you have the court officers, then
Exactly.
protocol officer, external librarian. And so.
Only judicial.
And
extent,
interestingly,
99.
Mizoram has that problem. A librarian cannot be an assistant registrar. But an assistant librarian can become an assistant registrar.
This all happened because of the creation of post and not, my lord, amending the.
No, here there is amendment.
No,
There is,
2024.
this is, here there is more amendment than required.
Yes.
Unlike the 87 rules where because of no amendment there is the problem, but here there is amendment because of that. This.
AA, BB, CC.
Yeah,
DD.
these are the created. Anyways, we direct that let this first this representation be placed
Please
before the rulemaking committee. Let them take a decision on that because there is also this is also done administratively without looking into without basing on the basis of the rules. The rules do not prescribe a quota.
That does not prescribe, neither ratio law.
It has been brought to the attention of the court during the course of the hearing that the Honorable Chief Justice have recently constituted a committee of judges to look into the Guwahati High Court have full rules to 1960. Look into as to whether any amendment is required in respect to the Guwahati High Court rules 67.
Service rules 1967.
Pusta. Taking into account the above, this court directs that pending disposal of the instant petition, the representations were submitted on 28/3/2023 be placed before the said committee so that the said representation would aid in the deliberation. List the matter after 2 months.
Deeply obliged.
Item 4,
Take on the committee. Committee will committee.
May it please hold. So if this matter pertains to my lord seniority cum merit, the petitioner, my lord, was appointed as a copist, grade 3, in the establishment of Chief Judicial Magistrate Nagaon. Thereafter, my lord, she was transferred to CGM Hosai. There, my lord, they took a resolution for filling up of 2 posts of UDA on the basis of seniority cum merit. That resolution, my lord, will find at page number 46.
You were at
Copies, ma'am.
in which establishment?
CGM Hosai.
CGM Hosai.
Hosai.
And now you want to become
UDA.
UDA.
Yes. Resolution is at page number 46. So they took a resolution for filling up of 2 numbers of vacant posts of UD assistant by promotion by applying the principle of seniority cum merit on 7/12/2023.
And UDA in which where?
CGM, same establishment.
CGM Hosai.
Hosai. Thereafter, my lord, on the next page, my lord, 47, on 19/1/2024, they again took a resolution for fixing the modalities, the criteria for the marks that will be the interview, my lord. That is at page number 47. So in that resolution, they said that an interview will be held where the total marks will be 50, and they also set up these 5 different criteria on the basis of which marks will be awarded. And they also decided that these 6 candidates will be eligible for applying. Thereafter, my lord, at page number 49, this order was issued calling up these 6 candidates in the interview.
So your name is Saru Devi?
No, serial number 2, Kobita Bora. Thereafter, my lord, at page number 50, they took this resolution on 22/1/2024, wherein they selected 2 candidates, Anupam Pal and Onirban Bose, and the candidature of this petitioner was rejected.
Which one? Page?
51.
What do you say? During the interview for the post of so-and-so, the following 2 numbers of candidates could not qualify
Yes.
for promotion to so-and-so vacant of UTA in the establishment of the as they were unable to get the minimum qualifying marks, 30 marks.
30 marks. And they selected these 2 candidates who were junior to the petitioner. And the marks, my lord, is at page number 52. So petitioner got 29.33 out of 50. So she missed by 0.67 marks. And the selected candidates got 39 and 41.
How many posts were there?
Two.
You got 29.33.
3-3. Yes. So our contention was that, my lord, they, my lord, fix. Since it's a case of seniority cum merit, minimum eligibility, minimum merit must be there. But to determine the merit, what they did was that they held an interview. That's okay, my lord. But they said that out of 50, the candidates will have to get 30. That will be around 60%. So 60%, 60
Out
out
of
of 50,
out of 16, huh?
50,
50.
50. So,
So
the
you
pass
are saying on the wisdom
yes,
of the selection board having 30
30,
out of 50.
50. That will be around 60%. So it appears that emphasis was given more on merit. Since, my lord, since in case of minimum merit, at least some working knowledge regarding the post should have been, my lord, the criteria, and then my lord, the pass marks should have been around 30-35%. But fixing, my lord, 30 out of 50 makes it that they were more concerned with the, my lord, merit rather than seniority. Then again, my lord, lordship pointed one, my lord, in the earlier hearing, lordship pointed out from this criteria, that is at page number 48. This uh, this criteria regarding higher qualification. Lordship had pointed out that, my lord, they put 10 marks against higher qualification. Now, in regarding UDA, my lord, the minimum qualification is HS pass at page number 48.
Okay.
Now, here in the resolution, my lord, they have not said
Where
the
the marks for those other one?
other one
Have
in,
have
in
you
their
given a
affidavit.
breakup?
In their affidavit, my lord. At
Huh?
page number 85, in their affidavit, respondent's affidavit, at page number 85. So there was no uniformity in giving the marks. One interview gave 6, another gave 7.
Qualification, HS pass, went to 5. Reading and understanding, 5, 6, 7, 9. So made it uniform at page 85 from top to the bottom.
Yes.
If they had the 10, they would have put the 10 also there. Number 6. Otherwise, it goes very serially 5, 6, 7, 8, 9.
Yes.
Now, tell me, what is Onupam Paul? What is his qualification?
His qualification is same, graduate. Graduate.
You are also graduate.
I am also graduate.
Then why 6 and 7 is given, Mr. Das?
Not Anupam Paul, I think,
At page number 41, minus graduation list, Anupam Pal, minus BCom, and he had some other computer diploma,
Tele and
Tele and DCA. Because since he is
41.
working as a typist,
41.
41, the gradation.
Saru Devi HSLC, Dhiren Lok Kavita BA, BCom Tele, Basic Computer. Sanjay Datta MCA, PGDA, Basic in
PGDCA,
Computer.
MA and PGDCA.
Huh?
Chandrali. Chandrali, MA and PGDCA, perhaps that's why Milord, the higher marks was given. 9.
You see, the problem which arises here is why one person differs from the other. One interviewer, because this is objective, it cannot be a subjective satisfaction, the qualification. Then why
Not
this
in-
particular
in my-
person?
In my understanding, your lordship's query is that different marks by the different interviewers.
Yes. No, not on any other aspect. Only on the basis of qualification. I'm only on the question of qualification. Why the three interviewers have given three different marks in respect to the same? One has given 8 to a person which is HS pass, to a BA, MA, whatever may be, he has given
Say for
8.
example, in Kobita Bora, one interviewer number 1, she had given 6. And interviewer 2, she has given 7
The next one has given
and
8.
8.
Now you kindly see Anupam Paul.
Yes,
One person has given 8.
8. Anupam,
One
seven,
person has given 7.
7, 8 and 8.
8 and 8. The second one, again,
8,
8, 8, 8.
8, 8, 8.
The third one, 9, 9, and the last one is 9. So this is 9. So
Others are 999.
9. Now, therefore, the question is, how do you say, how do you do this as regards when it is either you have to come up with something, a decision earlier, there has to be uniformity in respect to the qualification.
Look, so far as
Can there be a subjective satisfaction on the qualification? It has to be objective and based upon certain formulation done earlier.
Lord, the resolution says higher qualification. It appears from the resolution that as because they have got higher qualification, more marks were given to them, the selected candidate.
Yes.
Whatever they have got diploma or BCA or whatever they have been
No,
considered.
you very well give. But why one interviewer gives different? As
No,
regards
the
the,
interview is held in a manner that
I'm not concerned with other amounts. Only on the question of
true,
qualification.
my lord. What, Lord, it is
Because
not,
here
it's
we are
not
concerned with if one mark goes this way, this person gets selected.
true. Whether it is 1 mark, 0.5 mark, or 0.1 mark.
Not
Look,
point,
what-
not
whatever
0.1
it is.
mark. We are concerned with only 0.67 marks.
Yes, look, fine, it's all right. But my
Because of
understanding,
the fact that one person gave this candidate, the
No,
petitioner,
no, no.
yes, 24.
Milord Lordship will kindly appreciate one aspect of the matter.
Hmm.
The petitioner was not selected
Hmm.
because the private respondents got more marks.
Because the
Seniority
petitioner did
merit-
not get, you see, there are three interviewers. One interviewer gave 24. Page 84.
Yes, Milord.
The other interviewer gave 34.
Yes.
The other next interviewer gave 30. Because of one person giving 24, it all happened.
Milord, that's true.
Yes.
But the fact is that the interviewers has got that free play to give the marks. Each interviewer was given marks under each head or column, Milord. So that interviewer has got the leeway. They don't know that
Interviewer has all the leeway for every subjective assessment. There's no quarrel. I'm not saying. But how can there be an interviewer as regards the objective assessment, as regards the qualification? Yes, the petitioner may have been given all 7 or 6 unless you fix it. That look here, for this particular purpose, this should be this much. If a person is BA pass, we are going to give a 5, 6 or 7, whatever may be, some additional degrees. Where is it a formulation done prior to that? Otherwise, if just for example, these two interviewers have looked into it and the third interviewer has given just 25, he would have gone, this interviewer, this person would have got 30.
no, that even otherwise also,
Because of that interviewer only choosing to give 5 or 6 to this person concerned, what is your basis? As regards that particular concern, this interviewer
Not,
who has given so less, the CGM.
not so far. Not,
I'm
so
on, not
less-
on the other aspect. As regards personality, the ACRs, I have nothing to say. ACRs is also objective.
Personality is also general aptitude.
ACRs
also.
will also be
Qualification
objective.
is always considered as a,
The yeah, ACRs will be objective. There's no quarrel.
yes,
Personality, one can very well come up and say, then look here, I don't like the personality. It may be subjective of that person concerned.
yes.
But why? On general aptitude, he may not find her, his or her suitable. But as regards to qualification, you cannot.
Let's,
Higher education carries weightage in marks. How do you assess? You must have therefore mentioned higher education because there has to be a uniformity. How a person is being given, this particular petitioner is given by one interviewer 6, 7, and the second 7 and the third 8.
6, 7 and
How is it
yes,
possible?
6, 7 and 8.
In fact, there
There
seems
is
to be no
no bar in
uniformity.
fact, my lord.
Maybe they were not in talking terms.
My lord,
They didn't like each other. They may have selected, okay, we want this particular person only, do not want the other. There might be many permutations and combinations.
my lord, the
For this
interviewers,
court to look into it, first you have to also understand the backdrop of a seniority cum merits.
true, my lord. Not my idea of seniority cum merit is that they have followed the criteria. They have, my lord, ascertained the benchmark, and whoever was
So
found
in that regard, they should have also ascertained the benchmark as to
or
how the,
educational.
because they already had the names of those 6.
Yes,
At the time on the day on which they ascertained the benchmark, they had the names of those 6 and ought to have formulated how much marks each should have be given for their educational qualification. They already had it.
but perhaps, my lord,
Then it would
the
not have
manner,
differed.
my lord, the manner of, sorry, I'm sorry. My lord, the manner of calculating or ascertaining the minimum merit, in my humble understanding, it's with the employer.
Absolutely
The
no
merit in-
quarrel, no quarrel. But
We'll
as
have to
regards
see-
qualification,
We'll have to see whether thereafter the promotion has been given by virtue of seniority or merit. My lord, I have gone through the, my lord, judgments also.
whether the judgments say that you can have subjective satisfaction on the
My
qualification.
lord, the judgment says it is within the employer to, my lord, formulate any criteria to ascertain the minimum merit and see whether thereafter the promotion has been given by virtue of seniority or merit. If it is given on inter se merit, then it goes right there. But the Honorable Apex Court has said that the criteria which will be followed are just placed, my lord. Lordship will have a look, my lord, then the criteria which will be followed for asserting the minimum merit, that is with the prerogative of the employer.
Absolutely. So you
So
have
can
followed.
we go into
You have therefore followed. There's no quarrel with that. You say we're having 30 out of 60. Anybody getting 30 is the minimum cutoff.
yes,
No problem. You say that these are the 6 parameters by which we are going to look into it. The 5 parameters which are going to look into it, and each will be given individually 10 marks.
yes.
No quarrel with that. But how the educational qualification, which has to be an objective criteria, can differ amongst the interviewers? My only question is that I'm not on the other aspect. How does anybody, any of the Supreme Court judgments deal with that aspect? Only that. Can on the basis of just for example, can tomorrow, the ACRs which is there, everybody has been given an ACR.
10 marks.
ACR will be an objective satisfaction.
Yes.
Can you have a subjective satisfaction? My only question is this. Can you, for the purpose of consideration of seniority or merit, whatever it may be, in fixing the benchmark, can you have a subjective satisfaction on the ACR?
Easier cannot. That is
Similarly, for this also, qualification also you have to, because this will otherwise bring in the question of arbitrariness. How do you have a subjective satisfaction when all the three gives a different marks for the same candidate? You cannot have. We are more particularly concerned because the petitioner lost out with 0.67. 1 mark this way or that way would have changed the entire thing.
No, that's true. Her
One mark.
selection was
So
not
1 mark.
based. Her non
Because the other two candidate authorities gave the petitioner 34 and 30. Only for the fact that he has given 24, this has changed everything.
one interviewer gave
24.
You know, she could have got 1 mark in other parameters also. What I'm trying to, it's not about the 0.67 marks he got less. In comparison to the private respondents, she got she was not selected.
Not, there is no
So
comparison.
there is no inter-se merit
No,
comparison.
no, no. There is no comparison with the private respondents here. Here, the petitioner had to get 30.
Yes,
So therefore,
she did not get 30.
no, she didn't get 30 because of the difference, because there was no formulation made at the time of fixing the minimum benchmark as to how the qualification would be assessed. And this led to the arbitrariness.
So this, in my understanding, I
Show me one judgment to that effect, one judgment. That as regards the marks also, there can be a subjective satisfaction amongst everybody without fixing by the selection board. Yes, the selection board earlier knew very well who are the 6 persons who are being invited.
Yes, yes. Seniority list was already there. with
Everybody
qualifications
knew
and all.
about this thing, so they will get.
Yes.
Secondly, the selection board also knew what was the year, because in the gradation list their qualifications are given.
Yes, yes.
And why
there
on
was no
earth is
intention.
they have not done so?
Perhaps there was no intention.
There
on the
was no
part-
intention.
on the
It
part of
appears,
the
it
selection.
appears there is an intention of one of the persons not liking that person. Otherwise,
Lord,
why
there have been-
other
Also,
person
kindly see
gives
the
a
ACR
different-
report, my lord. She
Had-
is getting
Huh?
ACR report, my lord, at page number 58. ACR. All along, my lord, she has been getting very good. Since
She has got 9.
So that's
Yes.
why.
She has
That's
got 9.
And my lord, see the marks allotted against reading and understanding skill. A person who is getting very good and good, she has got 2 marks in the reading and understanding skill.
No, that will be entering into the wisdom of the selection committee member. Other members also gave 3 and 5. 3 and 4.
That way, my lord, this person should not even have been working there.
No, that's a different thing altogether.
Reading and understanding skill 2, and the first one got only 1.
No,
But
Can-
Mr. Das, one is also to understand, this is a very important aspect. Why? These people are, yes, to have a minimum benchmark is the aspect, which the Supreme Court says that minimum they should have this particular so that they can be given a promotion.
even in Milord criteria, fixing criteria also Milord.
They can have a minimum, there's no quarrel with that. But to have you also cannot forget that this is a case of seniority come merit.
No, Milord.
So to have this minimum in such a manner, just for example, this particular lady, Sharu Devi, who has not come before this court, she worked for 33 years.
Yes.
She worked for, she would have only
Now
two years left. Kindly appreciate this. Only 2 years left. On one hand, you have this criteria of seniority come merit. So the legislature or the person who has made the rules have thought it that we are not going to have it for merit come seniority.
At the same time, my lord, can we curtail the right of the, or the leeway given to the selection committee or appointing authority that don't promote an unfit candidate? That will also
Understood.
come.
So you have a minimum benchmark. That is why the Supreme
That's
Court does
right.
not says benchmark.
So
Does the
that's,
Supreme Court say that it is a
Yes.
benchmark?
no,
The Supreme Court says have a minimum benchmark which is required.
minimum merit.
So what is your justification to put it 30 out of 50? You see, the moment the Supreme Court uses the word minimum, it becomes justifiable. The Supreme Court could have said very well, benchmark. When you are
That's
using an exactive to a particular aspect, that means that it is justifiable to that extent. Why have you put 30 out of 50? Even your High Court do not have that.
30 out of 50, why? My lord, that question came up. And the Honorable Apex Court said that the employer has got the right.
Show me
In
that.
one judgment, my lord, in fact, in this judgment also,
No, show me that
Yes.
where the Supreme Court says that it is not justifiable.
In case in a judgment, my lord, 75% was held to be
my
too
lord,
arbitrary.
Shivaya also, in Shivaya also,
Shiva,
this
it was
court came.
50%.
This question came, my lord.
Let's see this. 2010 1 SCC 3
My lord, if your lordships kindly come to first, regarding the process of. Paragraph 11, 12, and 13, my lord. Paragraph 11, my lord, last 6 lines, my lord. The minimum merit necessary for the post may be
Let us
assessed.
start from 11 start.
Yes, my lord.
It's also well.
It is also well settled that the principle of seniority cum merit for promotion is different from the principle of seniority and the principle of merit cum seniority. Where promotion is on the basis of seniority alone, merit will not play any part at all. But where promotion is on the basis of principle of seniority cum merit, promotion is not automatic with reference to seniority alone. Merit will also play a significant role. The standard method of seniority cum merit is to subject all the eligible candidates in the grade, possessing the prescribed educational qualification and period of service to a process of assessment of a specified minimum necessary merit, and then promote the candidates who are found to possess the minimum necessary merit strictly in the order of seniority. The minimum merit necessary for the post may be assessed either by subjecting the candidate to a written examination or an interview, or by assessment of their work performance during the previous years, or by a combination of either two or all the three aforesaid methods. There is no hard and fast rule as to how the minimum merit is to be ascertained. So long as the ultimate promotions are based on seniority, any process of ascertaining the minimum necessary merit as a basic requirement will not militate against the principles of seniority cum merit.
So therefore, you are to have
So the
specified minimum. You see, the term used is very specific. The Supreme Court, why on earth the Supreme Court have used the word minimum? The Supreme Court could have said that the necessary merit, a limited merit or something to that effect. Why they say that, okay, you means a person, the basic idea of seniority come merit is, okay, you have a merit also plays a role by which a person who is being promoted should not be such that who doesn't know anything, who is not in a capable to do it. So you have an interview. You may have a written examination. You may have even a combination of both. And to assess and arrive at, again, they use the word specified minimum necessary merit.
Yes.
So you say that we want 60%. This judgment, however, does not say that you are going to look into the qualification.
No, it says that any criteria.
No. Kindly see.
Yes,
The standard or method for seniority cum merit is to play subject all eligible candidates in the feeder grade possessing the prescribed educational qualification
yes,
and period of service.
yes.
So this is already done. So a benchmark is already there. So you already have that benchmark. Once you have that benchmark, how do you bring in again the educational qualification?
In my understanding, Milord, there is no, Milord, eligibility qualification prescribed for the post of UDA, subject to, Milord, what my friend will say. In the rules, for the post of UDA, there is no specific qualification fixed. আচ্ছা, মূল হিসাবে তো দেখা নাই না। Residency service has been fixed as 5 years as LDA.
For promotion,
For
five,
promotion,
5
the
years
basic-
of services, LDA.
as LDA in the chief judicial establishment ministerial concern. So there is no qualification fixed.
Since the qualification was fixed for LDA, so that's why, my lord, perhaps in the resolution, they have said that the minimum qualification was HS pass.
No, where LDA put us in?
No, LDA, no.
It's not there for
Almost-
the LDA also. For it's there for grade 4. LDA is there.
So if there is no minimum qualification required, then you cannot put any qualification aspect.
Qualification can
And
always be
you
a-
want qualification also.
Look, qualification can always be a criteria for ascertaining minimum merit.
So then why you are having the interview then?
Milord, can we go into those aspects of the matter, Milord?
Definitely. Because you are seeing, you are looking into the wisdom of fixing 30 out of 50.
So for 30 out of 50, the judgment my learned friend was relying, that has been clarified by the Honorable Apex Court in this judgment also.
Let us see how the
Para number 20 of this judgment, my lord, of one Das Tiwari.
Bhagwan Das Tiwari was relied on by my learned friend, that your lordship will find para
Para 20.
19, 20, 21.
No, here, it is not said that the law is different. Doesn't say
says-
that Bhagwan Das judgment is wrong.
It says that the Bhagwan Das theory was decided on the facts of the case, and there it was 75%.
Anyways, both are two judges judgment.
Yes.
Where does anybody else say to the affair that you can take qualification as one of them?
Look, qualification in.
And how did you fix the minimum HS pass? When the rules does not say so.
Minimum HS?
How did you fix it?
No, minimum HS pass is not that they will be disqualified.
Yes, it
No.
says so. Minimum qualification, minimum HS pass.
I'll just check 1 second.
Kindly come to page 85.
Charu Devi,
I'm not Saru Devi.
no, I understand.
I'm only on qualification minimum HS pass.
Not qualifying minimum HS pass doesn't mean they will be disqualified. It is qualification minimum HS pass. Perhaps my understanding is the benchmark created.
That they will give 0.
No, they will give mark obviously, but above that they will give more marks because Charu Devi.
Just
she
for
was
example,
HSLC pass.
no, you see, Saru Devi is HS pass.
So that's why
No, you see, one
HSLC.
interviewer gives 8 marks. The second interviewer gives 6 marks, and other interviewer gives 5 marks.
To Kobita Bora, my lord.
No,
Sarudev,
to Saru Devi.
when she was only HSLC passed.
5, yes, then 6, then 8.
Either your selection board didn't know what to do.
That's yes. But even that be so, this HS, minimum HS is not for ousting any eligible candidate from the purview of selection. But I'm
You,
trying to
you see, in both these cases, Bhagwan Das and all this thing,
yes.
they were not looking into those aspects. They were not looking into educational qualifications.
Milord, I have tried my best to read all the judgment in this topic, Milord, seniority cum merit. Milord, all the judgment.
Here also, page 48. Qualification minimum HS pass.
48. No, it's there, Milord. But that doesn't mean the one who has not passed HS, that is HS means higher secondary, Milord. HSLC is
Over.
metric.
I also understand.
Charu Devi is HSLC.
No, HS pass.
No,
HSLC,
HSLC.
metric pass.
Metric pass.
Then also they gave it.
Yes, then
They
also
give
she was
8.
allowed to participate.
She was allowed and given 5, 6 and 8.
8.
No,
So
but I have-
therefore, there is no uniformity without fixing this.
if I have
There
understood
is an
correctly.
element of biasness, my lord. in the
No,
logic.
there-
whenever-
by the LS, my lord.
No,
When
I,
he
I,
said
I, I support his view. I support his view. This is a pure and simple case of biasness
Then,
of the CGM.
no, then no malafide has been alleged.
Not necessary. Balance in fact.
But this minimum HS pass,
When you
In
are
my
given
opinion-
a power to do something, and if you don't do it as per law, it is
the judgments
the
I have
malice in
take-
law.
I have tried to read all the judgments in this topic, my lord. I have seen.
Show me one judgment. No, Mr. Das, show me one judgment to the effect that educational qualification can be subjectively assessed. Only one judgment. Any high court.
But
High court was, I don't give you the Supreme Court also. Supreme Court may be difficult to get it. Any high court. And I would not even ask you to get it from SCC online or anything. You just give it from any put them legal also. I'm giving you.
Look, my understanding of this criteria is that, Miller, the
You-
Supreme
you
Court, Honorable Supreme
cannot
Court,
have-
Miller, Honorable Supreme
You
Court.
cannot have the educational qualification. The reason is by having an education, you are you have already prejudged that seniority, the merit has already gone for a sex.
Look,
And you cannot have objective. It's a subjective opinion.
This-
One can say this, the entire
Miller,
process.
this criteria of minimum merit
Only thing
is
is,
not for the.
only
not-
thing is, I'm not going to touch, yeah, one person will remain, the other person has to go. Now you
Look, the
choose out.
seniority come merit also
You
gives.
choose out who should go. Who has been given? Anupam Paul remains. Anirban Bose may go. But Anupam Paul's seniority will
They all
match
join on the
after
same day,
Gopinath
man.
Bora.
Same
I'm
day.
not going to do it, but this is the direction which I'm going to pass. Unless you show me. One judge
I'll make it.
from legal, I'm therefore I'm saying,
I'll
not
try.
from SEC online. It may be very difficult.
No, Supreme Court will be
With-
difficult because this.
no, there also.
Milord,
Supreme Court,
no,
there
but
also.
Honorable.
And with any journal which has spelling mistake also I will allow.
Milord, the Honorable Apex Court will not get the Honorable Apex Court judgment because I have searched. Because Honorable Apex Court never went into this aspect of the matter. Honorable
No.
Apex Court, no, one
Honorable
second.
Apex Court has duly gone into, in this case, which case you are referring to? This Rajendra Kumar has gone into detail in this.
No,
Kindly see,
no.
paragraph 20.
Milord, why I'm saying?
No, paragraph 20, the Honorable Apex Court goes in more minute details.
Yes.
Then what
yes.
is the difference? Work of performance during the previous years, interview 40 marks, 60 marks, 100 marks. Work performance in Bhagwandas, work performance during the previous 3 years, 30 marks. This is the, I think, the ACR aspect.
Yes, period of service.
Period of service at rate of 2 marks per year for completed period of year, maximum of 40, means 20 years they are going to take 40 marks. Interview 30 marks.
Yes.
Now, out of this, what has happened? You have put now interview 10, 20, 30, 40. Your interview is 40,
Yes.
not 50. Because HCR we take it as subjective.
Yes. ACR 10.
So-
Then personality, aptitude.
No, all these are other thing is interview.
Reading and understanding skill.
No, all these 2, 3, 4, and 5 is interview.
Yes.
So you are having 40 marks for interview. Whereas in both the judgments out here, it is 30 marks out of 40 marks or 30 marks. You are having
My lord will kindly
80,
have para
80
21
marks. 80 marks for interview here.
in this judgment.
In the 80 marks for
Yes.
out of 100.
40.
It is 80 because you are having it in out of 15. Huh?
Oh, yes.
So it is 80.
Yes.
80% you are having interview.
Yes.
Because we have to take it that you have made a subjective assessment on the basis of the qualification.
Milord, para 21, 3 lines, my lord.
3 lines.
Last
yes.
3 lines.
No, para 21, read the entire thing. It's
Yes,
very important
this
how intricately in detail the Supreme Court went into these. Read the entire.
It would thus be seen that the schemes for assessing minimum necessary merit are completely different in 2 cases. While work performance carried only 30 marks in Bhagwanda's case, it carried 60 marks in this case. While period of service carried 40 marks in Soen Bhagwanda's case, no mark was provided for period of service in this case. While the marks for interview were 30 in Bhagwanda's case, it is 40 in that case. The minimum qualifying mark was 78 out of 100 in this case. In Bhagwanda's case, the minimum qualifying mark prescribed was 45 marks out of 100. But ignoring the requirement of 45 out of 100, the selection committee adopted a minimum of 45 out of 60. That is aggregate of mark of work performance and interview only, ignoring the mark of 40 for period of service, though that was the highest segment. This court was persuaded to interfere in that case as the guidelines which prescribe the minimum qualification mark as 40 out of 100 was ignored, and committee changed the minimum qualifying mark 45 out of 60, thereby ignoring the marks secured for the period of service. Thus, the decision of so-and-so will not assist the appellant. So this was the ratio on which the conclusion was derived in Bhagwan Das case. Here it was
This is not a
78 out of.
this is how you distinguish. This
Yes,
is just
I'm sorry.
distinguish.
Yes.
So this is
So
not that.
in
But the question is, you show me one judgment
Rajendra Kumar.
where minimum qualifying marks is being taken on objective, subjective satisfaction.
Well,
One judgment.
I'll make an attempt, my lord.
Full stop.
I'll
Let's
make
go.
an attempt.
The
But
matter
may-
having
may-
been heard at length, a question arises as to whether the parameter set out while fixing the minimum benchmark pertaining to qualification could have been the subjective satisfaction of the interviewer, taking into account that the selection board, prior to holding the selection, did not formulate any parameters as to how the educational qualification is to be assessed. And this, this court further finds it apparent that the said aspect continued even during the selection process. It will be seen from the assessment enclosed at page 85, 86 and 87 of the affidavit in opposition filed by the respondent authorities, that each interviewer gave a different mark insofar as Sharu Devi as well as the petitioner in respect to the qualification. The question therefore arises that can on the basis of such subjective satisfaction, which otherwise ought to have been on the basis of an objective satisfaction, the selection can be sustained. Mr. H.K. Das, the learned counsel appearing on behalf of the Guwahati High Court, submits that there are precedents which takes care of such situation. So taking into account the above, list this matter again on during vacations. I think you should spend sleepless nights on 23rd of October 2025. Final disposal. Otherwise, Anupam Paul goes down. We give Kobita Paul. And where's the other side? You are there. You have to submit. Find out, help him. During the vacation, don't do anything.
Hello, dear, small player, item number 25. Item number 25, it fixed at 2 p.m. my lord. Only prayer, my lord, after motion item 22, can it be taken, my lord?
Huh?
After motion item number 22.
Time being item 22 for motion.
Where is Mr. Nayak?
Was supposed to come.
Hey, खाली एक मेट्रो का गूगल पे it has been Okay, we'll take it after some time.
Lordship.
Let him come.
Item 25.
Your problem seems to be solved now.
My lord, to the extent is okay, my lord, but lordship, only two judgment I would like to place in regard to the regulation, the recent judgment of Supreme Court. My lord, kindly have a look, my lord, will it save me to certain extent or not?
How many years you have been working?
My lord, since 2014, my lord.
How much?
2014, my lord. 10 years over, my lord. My lord, hey, my lord, paragraph 14, 15 and 18, my lord, the case is that, my lord, even, my lord, the outsourced employment was made by the corporation. They claim, my lord, regulations and other, my lord, that has been considered, my lord. And in another case, my lord, certain guidelines has been laid down also. And there is a discrimination also, my lord, because two other employees has been regularized, similarly situated.
You see, there's a difference
Yes.
in the two judgments. One is, you see, the case relating to Uma Devi,
Yes, ma'am.
where the question before the Supreme Court were as to whether the High Court under 226 can direct regularization, the Supreme Court said no.
No, clear, ma'am.
This has been followed by another judgment, another three judges judgment of Justice Chandrachud.
Yes.
In state of J&K versus District Bar Association,
ma'am.
Bandipara,
Yes, ma'am.
wherein it is further stated, more particularly at paragraph number 26 of the state judgment,
Yes.
that the question of the regularization is not a form of a recruitment.
Yes, ma'am.
One. Secondly, there cannot be a writ also issued for formation of a scheme.
Yes, ma'am.
These are three judges. Now, in the case of Dharamnath, which you are now, Dharam Singh,
Yes.
which you are now relying upon,
Yes.
Dharam Singh goes on another aspect of the
Yes,
matter
yes.
without touching much on Umadev.
Yes.
And says that the fact that there is no consideration by the state
Yes.
that this person concerned, that additional posts are required to be created when a particular person has been kept as a firm as an employee for more than 10 years
Quite right.
is justiciable.
Yes. Yes, quite right.
And it is on the basis thereof, in Dharam Singh, the Supreme Court passes certain directions.
Yes. Right, right.
Am I right?
Yes. Yes. Only lordship, so far Uma Devi's case is concerned. The another judgment I have placed, that is my lord Sripal, another. Paragraph 14 lordship, just look, it has been it has been interpreted to certain extent. Paragraph 14, my lord. The case is Bikram Nath, sorry, my lord, Sripal, another versus Nagar Nigam, Ghaziabad. Paragraph 14 is relevant.
Yes. No, this is being also interpreted in Dharam Singh.
Yes, yes, my lord.
This is paragraph 14 is on the basis of Jago.
Yes.
And that has
Yes,
been
yes,
given
yes.
this.
That
And
has been
therefore,
reacted.
on the basis of Jago, it has been given, but therefore, what is being sought to be done in Dharam Singh is the fact that the state has not considered of creation of a more post
More post.
or permanent post and keeping a person doing the same work which a regular employee is required
Uh,
to be doing
yes.
for a long time
Yes.
is a case by which it is a case of regularization.
Yes. But Lordship, kindly see
But
if
the only problem which I find out here,
yes,
with due respect to the Supreme Court, if it is a regular post,
yes,
whether you were appointed to a selection process,
yes,
because you see, the judgment in the case of Ashwini Kumar in 1997 postulates two preconditions when regularization is permissible.
yes,
First is that the person has worked for a long period. Secondly, he has been appointed properly
yes, yes.
by a person
Due
concerned,
process of law.
appointed after following a due process.
Due process.
And it is only there is some defect.
Yes.
And this aspect is further mentioned out there in Bandipara's judgment, wherein it is said that if you were the judgments, all these judgments say that you can only regularize an irregular person, but not a
Yes.
person who have not been appointed properly.
Illegality and irregularity that has been.
So therefore, can there be a question of regularization or creation of posts is the question.
Yes, madam. In my case, madam, kindly see that the creation of post doesn't require because post is already available. Vacant is also, vacancy is also there. Now they are processing for my recruitment to that post, madam, even madam, that process as per my information.
So you apply.
At my age is already over, my lord.
Your age will be decided. Your age will be taken care
No,
of.
Lordship, what I understood
But the
from
question is,
Lordship, what I
question
understood.
is otherwise, you also have to look into the aspect of there are thousands of persons who are also
In the similar.
deserving.
Yes, yes.
The fact that some gentlemen out there holding the post like your face out there and appointed you, that doesn't make that and you have been continuing thereafter.
My lord,
Makes
this,
you
my lord,
that
my lord,
you are to be given a preference. How do you then take because
my lord,
because regularization, as per various judgments of the Supreme Court, is also considered to be an exception
Yes.
to Article 14 and 16(1).
yes. My lord, so far the constitutional appointment schemes are concerned, my lord, that the process has to be in the light of the Article 16, the process has to be followed, others should not be deprived thereof. If suppose some, that part is also rightly covered in my lord, this my lord, SIPA's case, my lord, that how it has to be dealt with, my lord. It says that, my lord, so far the constitutional appointment schemes are concerned in the light of Article 16, my lord. It doesn't mean that the person who have already been in the seminal line and they are suppose discharging their duties since long time and their expectations are that they would be regularized. Second aspect of the matter, the labor law even it creates that it should not be permissible that the person should be kept in a labor position for a prolonged period, my lord. That paragraph is also there, my lord. Therefore, Lord, what I am saying, my lord, if this true judgment says, my lord, that the ultimate crux is that the person who is in continuing service and also supports discharging similar duty, my lord. And my lord, only that classification is somebody is permanent, somebody is regular. Therefore, the keeping a person, my lord, in a my lord, casual position, my lord, that is my lord injustice, my lord, shown that this is the ultimately reflection of this true judgment, my lord. Now, lordship, so far my case is concerned that can you see that what I'm discharging duty, the my other colleagues are discharging the same duty, my lord. And my lord, my term is 10 years, my lord.
But did you participate in this filling up of posts earlier?
Earlier, my lord, what happened that initially that selection process was not initiated. That is true, my lord. That has been, my lord, appointed casually by the office concerned. And I am continuing thereafter. Similar to other persons in paragraph 6 I have mentioned. They have also been appointed similar by the similar process. But their case has been regularized, my lord. Then what is different them and me, my lord? Paragraph 6, they have not denied, my lord. I have specifically mentioned one case I have even deal Rai Badur's one case. Before this honorable court, the prayer was made. This honorable court directed to consider by the LR department, LR consider the whole thing, and he was regularized. Same office, my lord, only that I am working in MSCT, he was in district, my lord. Session just start this matter.
No, unless there is a scheme How do you regularize?
But thing is that scheme we see that suppose the post is not there, yes.
Like in the Guwahati High Court, they have a scheme
Yes.
by which some percentage is in the grade post staff, some percentage
Madam,
is kept for direct recruitment, some for regularization.
Yes, madam. That in the light of that, madam, information has been sought from. That those who are casual employee, their information has
But
to be.
is such a scheme available in the district court?
But so far district court is number because High Court has directed, Honorable High Court directed all the respective district to collect the status of all those who are working in a casual status, my lord. And my lord, that information has been shared, and therefore, my lord, there must some purpose, my lord. Might be, my lord, to make it in a position of regulations or something else to deal with my lord, government, something else is there. And I was also there in that line, my lord. Now, suddenly, my lord, if I would be deprived therefore, my lord, then ultimately, what is the purpose of calling my name, my lord?
Huh?
My name has been supposed the information that has been sought from the Honorable Guwahati High Court Registry to all respective districts, those who are working in a casual position, my lord, employees as a casual. So therefore, the information sought for definitely for the purpose of making them regularized, my lord. Therefore, my lord, if
So whether there is a scheme,
scheme, my lord, that would be cleared by them, my lord.
whether there is a scheme in the High Court for regularization of the district employees,
I have to take instruction, but
because without that, it is not possible.
Yes, my lord. If suppose scheme is there, then problem is solved out to a certain extent.
And I think, Mr. Gogoi, you are for the finance, no? I think you should file an affidavit also.
If this is the main player now, otherwise, our condition will be better. You will have to work in the parliament. And following Umadesi, in 2013, OM has been issued, whereby we have sought for proposals from every department to forward the names of those master workers or casual workers or similarly situated persons who complete the.
Mr. The problem arises is you have not banned appointment on casual basis.
Probably that ban is there. There are notifications there. Despite that, none of the engagements are taken. It's there.
So if there is a ban, then how there is a financial approval?
Salaries are being paid.
Contracts are issued.
Because
Some are working.
if you see Uma Devi also, more particularly paragraph number 5, the Supreme Court says that the states still have the power to appoint on exigency basis. And in paragraph number 53, which is always the basis which has led to so much of litigation, it says that those people who have been working for 10 years, they should be regularized. And in future, the state should go for direct recruitment. But then also does not denude the power of the state for the purpose of regularization, for appointment on casual basis. Because there might be, in certain circumstances, requirement. You may not today have the funds for creation of a post, because creation of post has various other elements.
Right.
So therefore, you may require certain things. You may, unless you have similar policies, because you have only the policy, as I could see when I was taking up the pension bin, only for cleaners. You say that it has to be outsourced. The cleaners, I don't work well. They are to be outsourced. So therefore, remaining you still hold it that it is permissible. See,
Even in Umadevi, it has been held that even on casual basis, if somebody is engaged or appointed, it should be through Article 14 and 16. There should be some
selection process.
It is very clear that only para 53 is an exception. Only one-time measure has been given to all the states to regularize those persons.
the problem arises not because of that. The problem arises in view of the recent judgments.
Now,
The last 3 judgments.
those the orders are passed under maybe Article 142. Later, this honorable court. Bypassing
You
Umadevi.
see, when the Supreme Court says that the High Court was wrong,
Yes.
then can you say that the it was passed under 142. It can't be. That means the High Court should have exercised 226.
226.
More particularly in the case of Dharam Singh.
Yes.
Supreme Court says that it was wrong. And but the question arises there. It's a very interesting judgment. There means in all other aspects you get it. Where is the Dharam Singh?
Dharm
Where,
Singh is there, my lord.
where is it?
I have given my lord.
You're not giving.
I have given my lord Dharm Singh.
No, you are giving some other Sirpal as
Dharam
well
Singh.
as both are Sirpal. You are
Oh,
giving.
sorry, my lord. Both are.
No, Sirpal Guruj. You spelling mistake. See, in Dharam Singh, a very interesting observation is being made.
Last part, my lord.
Not last part.
Paragraph 18. What I said, no? In Dharm Singh 2025 by the way.
Finally come to paragraph 7. Give a copy to him.
Both copies are there, my lord.
No, there is only one copy you have given. One is you have given Sirpal and the other is this. Don't say all this. Mr. Yeah. Here what happened, the single judge as well as the division bench
Hmm.
on the basis of Uma Devi said that no question of regularization. The Supreme Court says here like this. The question before us is whether the High Court erred in law to adjudicate the appellant's principal challenge to the state's refusal to sanction posts and treating the matter as a mere plea for regularization. And if so, given the appellant's long and undisputed service, what appropriate relief ought to follow from this court? Having heard the learned counsel for the parties and perused the records, we are unable to endorse the approach adopted by the High Court. The original writ petition before the High Court expressly assailed the state's refusal dated to sanction the post for the commission and sought for a mandamus for creation of posts with consequential consideration for the appellant. The single judge of the High Court and the division bench of the High Court in appeal treated the matter as a bare plea for regularization, answered it only on the touchstone of the absence of rules and vacancy, and rested principally in Uma Devi. In doing so, the court failed to adjudicate the principal challenge to the state's refusal and the legality of its regions. In our opinion, such non-consideration amounts to a misdirection and in effect failure to exercise the jurisdiction. Then you see, Supreme Court makes a very in this observation in this judgment.
What are the last paragraph, sir? 18.
Ram Singh means I know all these matters because of the fact that in Nagaland, when we go only do these type of matters. But here it categorically mentions one thing. We believe a non-speaking rejection of the privilege.
Now, paragraph 20, that in Article 16, 14, 21.
Okay. You see, now the problem arises with this. In view of Dharam Singh, the court had framed, the Supreme Court had directed, framed this.
5 guidelines. Paragraph 19. following directions.
The approach of both the courts in reducing the dispute to mechanical inquiry about rules and vacancy while ignoring the core question of arbitrariness in the state's refusal to sanction posts, despite perennial need and long service, cannot be sustained. Only problem means
Lordship will see page para 4.1, 4.2, and 4.3, the factual aspect of that particular case. There, my lord, they were engaged sometimes in 1989 and 1992. After their engagement, there was a proposal for creation of post. It was in 1991 itself, and same was rejected in 1989, 1998. Thereafter, they have been, my lord, litigating. So that's a different aspect, my lord. Immediately after the engagement, there was a drive by from the, my lord, concerned department for, my lord, regularizing them by creating post. And finally, in 2025, they got the relief. And their main contention was that that particular
another aspect. You see the judgment in Uma Devi. The Supreme Court categorically observed that when a person is temporary, he knows where he
Yes.
stands.
Legitimate expectation won't come, my lord.
Question of legitimate expectation doesn't come. And the only thing is, we look into this judgment also, the only anxiety of this court is, if it is a question of creation of post,
Well,
means there's a requirement of a person to remain in there is a requirement of a post being created for
Yes.
that work.
my lord.
Can it be by post being created for the purpose, only for the purpose of regularizing, or that post is to be created for the purpose of
My lord, so far as, my lord, in 2005, my lord, there was a drive from the government, my lord, whereby in Jitendra Kalita's case, my lord, there was a drive for regularizing all the master workers and casual workers who were working at that point of time. And the cutoff was, my lord, 1/4/1993. Yes. So there, my lord, all personal posts were created. Moment the person expires or he retires, that automatically gets abolished.
here
They are
also.
not in the main category.
Here also, what they did, what they were doing is there were a direction for
Paragraph
creation.
19, my lord, directions.
Regularization and creation of supernumerary posts. All appellants shall stand regularized with effect from so and so the date on which the High Court directed fresh recommendation by the Commission and a fresh decision by the state on sanctioning posts for the appellant. For this purpose, the state and the successor so and so shall create supernumerary posts in the corresponding cadres without any caveat or preconditions. On regulation, such appellants shall be placed at not less than minimum of the regular pay scale for the post with protection of long drawn wages if higher, and the appellant shall be entitled to subsequent increment in the pay scale as per the pay grade for him. But it is not your case, or there is anything stated that there is requirement for creation of post.
My requirement, lordship, kindly see that persons is already required. The post which is already vacant, my lord, it is not a case that suppose they have to create a new post.
If the vacant, apply.
Understood, but lordship, kindly see similarly situated two persons. One is before
What has
the-
happened for them is there cannot be a negative equality.
the negative equality, but question discrimination is there. They were same institution, my lord. 1 year prior to that and 1 year after to me, my lord. Both were, my lord, regularized.
Not
And
satisfied.
post is, even the post is also there vacant lying exam today. Suppose they would be filled up by me.
Let the Supreme Court exercise 140.
Let them file affidavit, if they stand that, that scheme, whatever.
But I'm going to pass an order out here that you see the finance should direct to all authorities, even to the judicial department, to the effect that there cannot be an appointment until further orders when these people are appointed only against a particular proposal. In respect to all other persons, what happens? It is permanent employees, it is already there.
Yes.
You already fix it out in your budget. You already fix it out in your consolidated fund,
My lord.
how it is to be
Lordship.
affected. But how for casual employees who are dependent on a proposal being submitted and that proposal being accepted, the authorities are passing orders that their appointment is until further orders. It
Yeah.
could have been only up till the proposal, the financial proposal is there. This is the prime example of that.
Lordship.
Here, without even seeking for a proposal, they have extended it until further orders. How on earth these people do it?
And in fact, my lord, nothing on record to show that, my lord, he is working on a permanent post. He may be a person who has been
You
engaged other.
cannot, under any circumstances, issue directions or any of these appointing authorities when they are appointing has to appoint on the basis of the budget proposal. They have to give a budget proposal. They require them. They have to give a budget proposal. For that, you have to give an extension.
Well,
In a question of extension, you cannot have it until further orders.
right.
It means you are giving it whatever may be. Then who is going to pay?
Well,
The finance is not going to approve this. This time it was a special case. The finance got an approval done. Otherwise, in the case of another case of one Mr. Bipul Bushra, he retired after 2 years. They got the finance has given that. Yeah?
Lordship, that one learned friend placed whether any schemes lying out there, in respect of this, my lord.
That is another thing, but I'm passing an order to that effect that I'm not satisfied with your case. For regularization, not satisfied.
Lordship, give me one date, my lord. I will come with more
What?
petition if suppose anything, my lord.
There is nothing more.
My lord.
I think we have.
Because my lord, two things are, my lord, still, my lord, required to be addressed. My lord, first thing is about existence of scheme, my lord. And second thing, my lord, so far this judgment is concerned, my lord.
No, your basic case is not there for creation of post. You want just for regularization. This is your simple case.
Yes.
Maybe issue the direct release also and some mandamus to the effect that the job of the present petition is required to be regularized in the office of either the respondent with immediate effect. This is your case. This is the case where the Supreme Court says in the case of Dharam Singh also, the High Court made a mistake of taking it as a simple case of regularization. It is not that. This is not a case of where you are asking for free there, and more particularly these people where Mr. Gogoi is right on that aspect. These people were working prior to Uma Devi. Yes. This is a very important aspect.
My lord, but my lord, I have gone through, my lord, some cases in the light of my lord Dharam Singh, this case, my lord, different high courts, my lord, even afterward also, my lord. If we see timelines of that cases, my suppose that has been considered, my lord. One is Jammu Kashmir's case, I think a high court case was there. It is not a case that after Uma Devi's case that has not been looked into, my lord, for regulation. My lord. That was also in the light of Dharam. This
Jammu Kashmir High Court have given regularization direction for 2,000 employees. And this resulted in that judgment which went, and that too in a PIL. And this resulted in the judgment in the case of state of J&K versus District Bar Association Bandipur.
Yes.
And that was the issue there. And this is after Uma Devi.
Yes. Therefore, my lord, the thing is that it is not a, my lord, state cut, my lord, bracket formula which required to that after Uma Devi's, my lord, whatever situation, because my lord, I am doing this job, my lord, as per their, my lord, wish and will, my lord.
No case. You should be happy with this.
Proceed,
As regards your prayer for regularization, I close it now, giving you liberty to submit representation, and then you may again. And you know how to do it then. This is the only way out, Mr. Samaria.
Yes.
Only way
Lordship,
out
no,
is
Lordship will definitely
you
do.
develop your case in that line. That is not your case here. I keep this, I don't dismiss it. I drop this as regards your prayer, giving you the liberty to submit a representation for regularization
Madam.
and then take it up.
No,
This-
we leave it to your lordship, whatever best thing for me, my lordship.
I have nothing, no.
I'm my lord helpless person, my lord.
No,
Now
no,
he's-
one thing, you see,
Lordship, the position is that
whatever maybe you, if you see paragraph 23 of Uma Devi, it's
Yes, ma'am.
absolutely clear. The Supreme Court categorically says that when a person is appointed as a, what do you call that, temporary employee, he knows what is his situation. He knows that he would never get, he may not get, and therefore the question of having a legitimate expectation does not arise. Even the Supreme Court goes to the extent of saying that getting a regular scale of pay also is not there.
Yes.
He doesn't have. And these are constitution bench judgments we are bound. So I think you develop your case in this line. Now, heard Mr. S. Samaria, the learned counsel, appearing on behalf of the petitioner, Mr. B. Gogoi, the learned counsel, who additional advocate general, who appears on behalf of the respondent number 1,
1, 3, and 6.
1, 3, and 6. Mr. G. Busher, who represents the respondent numbers 2, 4, and 5, isn't it? Full stop. The petitioner herein has approached this court seeking primarily for two reliefs. The first relief being that the petitioner have not been paid his salary since May 2025. And the second relief is that a direction should be issued to the respondent numbers 2, 3, 4, and 5 to regularize the petitioner in the office of the respondent number 4 and 5 with immediate effect. This court had issued notice on 17/7 on 18/6/2025 and sought for appropriate instructions. An affidavit has been filed on behalf of the respondent number 5. Respondent number 5, wherein it has been mentioned that the petitioner was engaged as a casual grade 4 worker on a need basis and not through any formal recruitment process for regular appointment. It was further mentioned that the services of the petitioner was continued from time to time as per requirement and availability of the budgetary sanction. The petitioner's fixed remuneration was rupees 9,000 per month, and he was duly paid his remuneration till April 2025. So for the month of May 2025, the salary bill of the petitioner was prepared and submitted to the respondent number 6. But the same was returned by the respondent number 6, citing objection based on OM number FC bracket Roman 3 oblique 24 oblique 92 oblique 397 dated 16/12/2000, as well as Rule 12 capital A bracket 3 of the Delegation of Financial Power Rules 2022, which mandate that DDOs are not authorized to engage casual employees on wages without the financial concurrence from the Finance Department, Government of Assam. Full stop. This court further finds it very pertinent to take note of that there was no financial approval granted by the finance department for the purpose of engagement of the petitioner with effect from 1/4/2025 to 31/3/2026. Full stop. Mr. B. Gogoi, the learned additional advocate general, who also appears on behalf of the finance department, submits that in terms with Article, take on Constitution, Article 202 of the Constitution, hey, last, don't follow this. Hey. Two of 202 of the Constitution, the annual financial statement which is prepared is based upon proposals duly submitted. The petitioner herein, who have not yet been appointed, who was appointed on only a casual, only as a casual employee, such funds for such engagement for engaging casual employees would not feature in the annual financial statement unless due proposals were submitted. The learned counsel, the learned additional advocate general, further submitted that in the instant case there was no such proposal submitted, and as such, the question of there being a financial approval for engagement of the petitioner with effect from 1/4/2025 to 31/3/2026 did not arise. This court further duly takes note of that this very aspect of the matter was brought to the attention of this court on 5/8/2025, whereby this court passed an order thereby directing the respondent number 5 to submit a proposal with justification to the Judicial Department of the Government of Assam. And the Judicial Department of the Government of Assam shall thereupon forward the same to the Finance Department for consideration of the proposal as regards granting of ex post facto approval for the period sought in the proposal. It appears that thereupon a proposal was duly submitted by the respondent number 5 to the Judicial Department of the Government of Assam. And on the basis thereof, the Finance Department of the Government of Assam had granted a ex post facto approval. And this aspect of the matter would be clear from the documents which are kept on record and marked with the letter X. Full stop. Mr. G. Butcher, the learned counsel appearing on standing counsel, who appears on behalf of the Guwahati High Court as well as the respondent number 5, submits that in view of the ex post facto approval granted in respect to the engagement of the petitioner under the establishment of the respondent number 5 for the period from 1/4/2025 to 31/3/2026, the petitioner would now be paid his dues. Full stop. Taking into account the above, it is therefore the opinion of this court that the petitioner's first grievance, which have been set out in the writ petitions, stands redressed. The second ground, the second aspect of the second issue which is involved in the instant proceedings is as to whether this court should pass appropriate directions directing the respondent authorities to regularize the services of the petitioner in the establishment of the respondent number 4 and 5. First, the learned counsel appearing on behalf of the petitioner, Mr. S. Samaria, submitted that taking into account that the petitioner had been working from the year 2014, the petitioner ought to have been regularized, taking into account that similarly situated persons have also been regularized. By contra, Mr. B. Gogoi, the learned counsel, submits learned additional advocate general relying upon the judgment of the Supreme Court in the case of Secretary so-and-so versus Uma Devi reported in 2006 for SCC 1, submitted that the Constitution bench of the Supreme Court had categorically observed that the High Court, observed that the powers under Article 2 to 6 of the Constitution should not be resorted for issuance of directions for creation for regularization of employees. This court further finds it very relevant during taking note of another very important aspect of the matter, which the learned counsel appearing on behalf of the petitioner had pointed out, is in respect to the recent judgment of the Supreme Court in the case of Dharam Singh and others versus State of UP and others reported in so and so. And the learned counsel submitted that though the Supreme Court in the case of Uma Devi Supra had observed that the High Court under Article 2 to 6 of the Constitution ought not to issue a direction for regularization of the employee. However, the learned counsel submitted that in the recent judgment, that is in the case of Dharam Singh Supra, the Supreme Court had made it very clear that when the respondents, when the authorities who are a state employs a person for long duration on a temporary ad hoc basis and without creation of a post in order to deprive the person of his legitimate dues, the said aspect is justiciable. This court is of the opinion, this court having perused the materials on record, do not find that such a plea have been raised, or the petitioner have approached the respondent authorities in that aspect. It is therefore the opinion of this court that an opportunity should be granted to the petitioner to approach the authorities in that respect. And depending on such what steps are being taken, the petitioner can be left at liberty to take the course available under law. Accordingly, the instant petition stands disposed of with the following observations and directions. Number one, as there has been an ex post facto approval being granted by the Finance Department for the period from 1/4/2006, 25 to 31/3/2026, comma. The respondent number 5, na? Five. She will be the DDO, shall release the dues to the petitioner as per his entitlement. Number 2, and the same be done at the earliest. And within a period of 15 days. Payment is already, finance is given.
Some transfer is going on.
What transfer? There's no more transfer. Transfer everything as a. There's no transfer business.
Just to hand over.
That person has now become now the district judge of Jorhat. That's a different thing. But the post is there. Somebody has now been there. She's in Gwalpara, na? Okay, Gwalpara. The district judge from Karbi Anglong is going. He will take care of. Within a period of, he has no money. If he gets money, then only Mr. Samaria can have something.
No, he's now selling vegetables, my lord, morning time.
Huh?
Morning time, he's now selling vegetables, my lord.
Otherwise also he has to. You cannot survive with 9,000. Within a period of 1 month from the date of the present order. Number 2. This court grants the liberty to the petitioner to submit a representation before the concerned respondent authority seeking regularization. And in respect to his claim for regularization, not seeking, in respect to his claim for regularization. Depending on the outcome, the petitioner would be entitled to such liberty, would be entitled to approach, resort to such legal remedies as available in the law.
Time frame may be given, my lord, to apply and my lord, take their decision or regulation.
No, that I am not going to do.
Well,
That is
otherwise,
why
they
I
will-
not even use the word consideration. No, that I'm not going to. Therefore, I've given you the liberty to approach.
No, we will approach, my lord. My lord, it's time, otherwise they will
You-
keep pending, my lord.
Mr. Samaria, you are not understanding. This I'm giving you. You frame up your case in this manner,
Yes.
in this manner of this, and then submit it. Then come back again. That
Understood.
is why I'm not saying about the consideration. Consideration, they know.
Yes.
Therefore, I say that depending upon the outcome, you will.
Again, another round.
This is a very, obviously, the moment I said it, that is a round.
Yes, yes.
That continuation part, my lord, will be till.
Oh, so
Otherwise it
before
gets-
starting with the record, this court finds it very pertinent to make an observation in respect to the practice which is being followed, and more particularly in the present case. It is noticed that unlike permanent employees, in view of Article 2, unlike permanent employees, there has to be a financial approval every year, financial approval so that the services of casual, temporary oblique ad hoc employees can be continued. In the instant case, it is seen that even without submitting any proposal, or even, and it is seen that without considering these aspects, and more particularly, and it's seen that without considering these aspects, a tendency is seen amongst the competent authorities to appoint temporary, casual, public ad hoc employees for periods without obtaining the financial approval or beyond the financial approval. This court would be more appropriate. This court finds that appropriate directions that on account of such difficulties arise for employees, for temporary, casual, ad hoc employees, in getting their pay after the financial approval period is over. The finance department may consider issuance of appropriate notifications to resolve the said issue. I think this is enough. Without touching his thing also.
Yeah, I'm little bit away. Developed.
Admission attempt 5, 6:02 p.m.
Oh, this one, Chilsha Municipal Board.
Lord, before your lordship starts the matter, the other day I just told that there is a publication in the social media, just for a while, your lordship can see to that. In the context of the order passed by your lordships, what was coming from them, your lordship kindly see for a while.
What is this?
My lord, in the social media, my learned friend's client, my lord, they posted this.
Yes, read it. You read it. Very difficult for me.
Oh, I should read.
Yeah. He also should know. Then he, otherwise,
My lord,
Mr.
I
have been conveyed by
my,
something is being done ex parte against him.
I have already intimated him.
Been conveyed by my senior on the last.
So are you liking it?
No, my lord,
Is it in good taste?
my lord, after coming to know about this, I very on very strict terms, I conveyed that if this is what is going to go on, then it will be difficult on my part to continue with this brief. So thenceforth, my lord, from their end, they have assured that this practice will not be indulged into. Now, if for what has been placed before your lordship, this was in the context of the earlier order. Now, that earlier order was interpreted in this manner, which is not a happy one. My lord, conceding to the fact that it's absolutely ridiculous on the part of whoever has conveyed in this manner.
Okay, anyways, let us come to the point.
My lord, on the last occasion, your lordship had given a direction, 19.8.
Lord, your lordship, I
When the
have,
decision was taken for enhancement of the water tap charges.
now your lordship wanted to see the record.
Hmm.
Lord, before the enhancement, whether there is.
I
any-
thought the records, the bigger one was the records.
No, this one,
The smaller one is the records.
well, everything is there, Lord. I have flagged it.
Okay.
The relevant papers, your lordship will find the flag mark, your lordship will get the thing from there.
So you have put 300 per month. 300 betterment fees at rupees 300 per month per tap.
Yes, tap rate.
And on the basis of which you are still fee for the previous year. But this tap charge was earlier there also.
Earlier it was 125. It is right from 2014.
So when, since when they have increased?
My lord, 2024, it went from 125 to 300.
From 2024?
It went from 125 to 300. Earlier on, it was 80 in 2022.
It's
2022
okay,
also.
but step rate charge, old rate is
100,
125, new rate is an enhancement here. Executive officer has done that. This was done on 9/2/2024.
My lord. Prior to that, it was as
125.
it was 100 as told by my senior sometime in 2022.
But after that, what happened when this elected government came? I mean, they reduced it in order to get their broadband to be make very tight. So they reduced it. Then when it did not work, my lord, they again announced. Just put all over it.
So they have done it as a separate betterment piece.
Yes.
Now, my lord, the affidavit that was filed on the last occasion whereby it has been clarified that it was not tax, it was a fees and with an element of quid pro quo involved. Now, the quid pro quo here, what has been highlighted is it is pursuant to a scheme because the value has increased, therefore a scheme under which this particular fees has been levied. Now, to that, my lord, in their affidavit, they have relied upon certain provisions of the Assam Municipal Act. First of all, to start off with, they have said that it is a fees within the meaning of section 68, subsection 1, clause K. So far section.
Municipal economy. After I come back, I will take up that matter. Huh? Where is it, Mr. Nayak? Ask him to be there. That the order has to pass because he is also waiting, Mr. B. Chetri. Mr. Doctor, you are not a standing council of Silchar Municipal Board?
I am standing counsel.
Now, why yesterday there was one matter out there? Yes, kindly inform him about this thing. He has accepted the notice on behalf of the Chief Executive Officer. Matter has been going on. He's asking for some orders which, if passed, would have a detrimental effect upon the Silchar Municipal. I postponed it to some other date, asking him to file an affidavit.
We have been implemented as a party.
They're already party. And
They-
and the government, the petitioner says that service has been done, but they are not appearing. Yes, we do one thing. Where's Mr. Chetri? His matter, I'll pass the order. Just wait. Motion.
Lordship, Mr. Nayak is on legs in another court. Lordship may take up the matter at the end of the list.
Yeah, he has come. Yes, Mr.
So far as my instruction is concerned, procedure for application for registration is online, but approval is manual, Lordship. Once approval is given, only then they receive that. And they applied for registration, but it was not approved.
You cannot stop him from approval.
Yes, that is that one aspect,
So you give him the approval, that I'll pass a direction.
Lordship. And so far as second is concerned,
Whether you consider or not, that is your lookout. But I think this matter needs an early thing. I take up this matter and fix it on before vacation or date. You file a short affidavit, whatever you feel like. And by 24th or 25th, you finish it up. Issue is short, but the only issue out here is this. On 8/2/2025, you say that these are the persons concerned who have, there has been some deficiency in service. Did you take any action against them earlier? Because now you are bringing a guideline at a later stage and saying that, okay, we are blacklisting those people who are blacklisted will be there.
Lordship, in this 21/8/2025, that is Annexure J,
No, 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 no. First is here. You kindly come to this annexure.
the table,
G.
Lordship, yes.
Annexure G is something dated, I think, 21 to 23. What is the date of this document? Annexure G.
There is no date. No signature.
Where have you got this?
Well, it only that has been provided in the office that
Original.
no, we do not have. Only that part has been provided.
But kindly come to Annexure D, Lordship.
Annexure D. Page.
Please. The laboratory test.
Twenty 23. I think.
That is the laboratory test. The table, the connected papers are the Annexure G.
So here you have only given of MS, Mother and Sons Group. That is petitioner number 2. Annexure E.
Others, I have the documents, my lord, I have to correct.
No, no, you have not enclosed those.
No.
And there is no mention out here that that is satisfactory.
No. It is there, my lord.
Where?
This headmaster has signed, my lord, in the below, my lord, Anjan Nath Pradhan Hikhyok.
And when
I
did you give this document, Annexure E? What is the date? So there is no testing thereafter.
Now already it was done, and accordingly it has been considered, and my salary, my whatever the bill has been there, after testing all these things, that has been done.
How do you know?
That statement I have made, madam.
No, statement would not do. These are factual foundations.
If necessary, otherwise I will place all this, whatever it is, my.
You do one thing. We have it on 24th or 25th. Finish it up. Now, one thing can be very well done is Annexure J, which is there.
Yes.
You think about it when we take it up on the final day. However, at the same time, all firms who supplied poor quality material will remain blacklisted even if they have GST registration. Those who have supplied as poor quality is okay. But if they have supplied later on and replaced it, you will consider. I think that by that you can meet your demands. And you are satisfied. You have to then take a call from those authorities as to whether they were satisfied. Just for example, here, the petitioner, there were some deficiencies there in respect to the petitioner number 2. He says that, okay, I have supplied. Now, whether that has been satisfactory or not, there is no test reports and all. So therefore, these things needs to be verified by you and do it. So that is how we can take away the problem with the blacklisting which is being done in case of them on these petitioners. And by that because after all, if a person has given bad quality of quantity, they cannot be allowed. Whatever may be the rules of blacklisting, but they cannot be again allowed. They can participate, but they cannot be granted again another contract because the people will suffer, the children will suffer. So I think you just think about when we pass the final order on 25th while calling on all the other writ petitions. This how, if they in the meantime, pursuant thereto on complaint being given because that letter was written, if these persons have remedied it by supplying those documents, the clause properly, and they were satisfied with that, then you can take a call on that.
Yes.
I think this is the way out by which we have to finish up this matter so that all the supply can be completed by this.
Timeline should be followed. Yes.
Then only it will be. Otherwise, it will stall the process. Because if the other petition, it has been given issue notice making returnable by 4 weeks. And by these 4 weeks, and the proceedings have been stalled.
Not stalled actually.
Yes.
Therein direction has been passed. They will.
No.
It will be the authority to decide.
Kindly see the 103. Accordingly, in the interim, the petitioner shall be allowed to participate in the open tender process in those schools where the tender process has not been completed. It is made clear the participation in the process shall be subject to further orders of the court.
Last line, last paragraph.
Needless to observe, the acceptance or rejection of the AI is within the authority and which is subject to fulfillment of the terms and conditions. Then tomorrow, if the court holds it, that the participation is wrong, then what happened?
At the same time, Lordship, we are also given the authority to decide.
You can go and decide if you want.
So Lordship will.
So I'll make that clarification on that document annexure J, page 92. Make that clarification. You can verify that.
If they rectify it,
Now, if they had already rectified, not rectified, rectified
Earlier, Lordship.
earlier,
In that situation, Lordship, they may be allowed.
they may
That
be.
consideration will be done by the authority
Ah,
and take a decision. Lordship.
Because they say, because it is their own statement that they have rectified.
Yes.
So you verify. If they have rectified, then allow them to participate.
Lordship.
I
But
think
in
this,
any case, Lordship, the timeline set in the guideline, Lordship, will be followed.
so
that is
therefore, we
15th
fix
of
it on
September.
25th.
15th of September.
No, that 15th of September is that whether you pass an order, that is your lookout. But we need to finish up this. Do you think that we should finish it up or not?
Yes. It's better.
Before vacation or there are too many other matters. So if
Before
you
vacation.
wish, I can. Otherwise, not necessary.
For
I'll
the
leave it.
time being, your Lordship is allowing their,
Registration,
that will be done,
And
Lordship.
registration, and the participation shall be subject, because they categorically say on affidavit that they had there were faults found and they rectified by replacing the with good ones. That is their own statement.
Yes.
So you'll verify that, and subject to verification, you allow them to participate.
Lordship.
Or subject to verification, if you are not in a position to verify within these 3-4 days, may be difficult. You decide as regards passing of orders, whichever you feel like. Think about it till I pass that.
No, Lordship, just one, if they will, if they are allowed to participate, Lordship, they will participate only in those cases, Lordship, where the submission process is not yet over, bid submission is not yet over. That is automatic, Lordship. That is what, if 15th is the last date for issuance of the work order, Lordship. In the meantime, all the school must have issued the bid document, I mean the bid, tender, Lordship. In that situation, Lordship, within these 3 days, against which bid, Lordship, they will participate.
But okay, then we did participate. Issue notice making it, then we have it after vacation.
Lordship.
You get the time.
Yes, Lordship.
Huh?
If Lordship is giving us the authority to verify and
You
allow or
verify.
not
That
to
I'm
allow,
giving you.
in that situation, Lordship will take up after vacation.
Issue notice making it returnable on 22nd of October 2025. Mr. Tina accepts notice on behalf of the respondent numbers 1 and 2. So extra copies of the writ petition be served upon him during the course of the day. The case of the petitioners herein is that, is that they were issued work orders for supply of school uniforms. By various schools in terms with the guidelines issued by the respondent number 2 from time to time. The petitioners herein duly admit in their writ petition that while making those supplies, there were certain deficiency there were the material, the school uniforms so supplied duly admit in their writ petition that while affecting the supply, some of the items so supplied were not as per specifications. of the guidelines on school uniforms for the financial year 2024-25. It is further the case of the petitioner that immediately on coming to learn that the school uniforms so supplied were not as per specifications, the petitioners immediately replaced those items to the satisfaction of the school authorities. Be it as it may, the petitioner could obtain a list of vendors whose lab tests were found not as per requirement in the last year, which have been enclosed in Annexure G, wherein the names of the petitioners have been included. Case of the petitioner herein is that in terms with the recent guide dated 8/8/2025 issued by the respondent number 2, there are certain specifications, certain stipulations issued whereby the petitioners have been debarred from participation. Mr. B. Chetri, the learned counsel appearing on behalf of the petitioner, submits that one of the conditions for participation is that the vendor has to be registered in the Shiksha Setu. Apart from that, the vendors who are blacklisted due to supply of substandard quality of uniform during the year 2023-24 and 2024-25 have been stipulated that they would not be considered, shall not be considered to participate in the tendering process and also in the quotation process. The case of the petitioners herein is that though there were supply of school uniforms made by them, which were not as per the specifications, but the petitioners have duly remedied the mistake by supplying the uniforms as per the specification to those schools, and that too to the satisfaction of those schools. Under such circumstances, the question of not allowing the petitioners to register in the Shiksha Setu and also not to allow the petitioner to participate in the tendering process as also in the quotation process does not arise. It is under such circumstances the petitioner have therefore sought for reliefs, certain interim directions. Mr. B. Chetri, the learned counsel, further submitted that the learned coordinate bench of this court in WPC number 4987/2025 and 5168/2025 has passed certain interim directions to the effect that the petitioners therein have been allowed to participate in the open tender process in those schools where the tender process have not been completed, and making it clear that the participation of the petitioners in those tender process shall be subject to further orders of the court. The learned counsel for the petitioner further submitted that the learned coordinate bench of this court further observed that the acceptance or rejection of the tender of the petitioners would be within the authority of the tendering authority, within the authority of the tendering authority, which is subject to fulfillment of the terms and conditions of the tender. Per contra, the learned counsel appearing on behalf of the respondent numbers 1 and 2, Mr. P. Nayak, submitted that in respect to short quotations which relates to works below 1 lakh, the work orders are required to be issued by 31st of August 2025. And in respect to open tender, the work orders are required to be issued within 15th of September 2025. The learned counsel appearing on behalf of the respondents submitted that the petitioners very well knew that their names were inserted in Annexure G. And at the nick of the time, the petitioners have approached this court so that there is no chance given to the respondent authorities to make appropriate verifications. The learned counsel further submitted that by the communication dated 21/8/2025 issued by the respondent number 2, it was made clear that those firms who have supplied poor quality material would remain blacklisted, meaning thereby that if the petitioners have supplied poor quality materials, they would be blacklisted. The learned counsel further submitted that this communication dated 21/8/2025, however, was not considered by the learned coordinate bench while passing the orders referred to by the learned counsel appearing on behalf of the petitioners. The question which arises before this court at this stage is as to whether the petitioners are entitled to certain interim directions. This court duly takes note of clause H C of the guidelines dated 8/8/2025 issued by the respondent number 2, wherein it is stipulated that only those vendors who are registered in the Shiksha Setu would be allowed to participate in the tendering process. This court inquired with Mr. P. Nayak, the learned counsel appearing on behalf of the respondents, as to how the respondent authorities can bar the petitioner from registering in the Shiksha Setu, that too when the petitioners have duly submitted the application online. Inasmuch as the guidelines do not prohibit registration, the learned counsel appearing on behalf of the respondent numbers 1 and 2 upon instructions submitted that though the application seeking registration is required to be done online, but the approval for the registration is done manually. The legal counsel with all fairness submitted that the respondent authorities are not adverse to permitting the petitioners to register in the Sixer Setu by granting due approvals. Full stop. Taking into account the above, comma, and a full stop. The next question which arises, taking into account the above, it appears, therefore, that one of the grounds of grievance on the part of the petitioner not being able to register with the Sixer Setu stands redressed. The second question is as to whether the petitioners can be allowed to participate in terms with clause, in view of the stipulations contained in clause D and E, the clause D of in subclause D of clause H of the guideline dated 8/8/2025. In the instant case, it would be seen that the petitioner duly admit that the petitioners have duly supplied, not as per specification of the guidelines of the extent of the then existing guidelines, the school uniforms. However, it is also the case of the petitioners that the petitioners thereupon remedied their mistake and supplied the same to the satisfaction of the response of the school authorities. Taking that to be the pleaded case of the petitioner, it is therefore the opinion of this court that if the petitioners have remedied their mistake by supplying the school uniforms to the satisfaction of the school authorities, the petitioners can be permitted to participate. However, subject to verification being carried out by the concerned respondent authorities. Next. This court cannot also be unmindful of the fact there's a timeline stipulated in subclause E of clause H of the guideline dated 8/8/2025, which stipulates that in respect to open tender, the work orders are to be issued within 15th of September 2025. The learned counsel appearing on behalf of the respondents have duly submitted that the petitioners have approached this court at the nick of time. And in all likelihood, in most of the schools, as on date, the period would be over.
Last date of submission. Yes.
Would be over. It is the opinion of this court that the learned coordinate bench of this court in the two orders so passed in the order dated 59/2024-25 in WPC number 5168/2025 had categorically opined that the participation of the petitioners therein shall be allowed only in those schools where the tender process has not been completed. The petitioner this court is of the opinion that the petitioner herein is also entitled to similar interim directions. Accordingly, this court passes the following interim directions. Number one, the respondent authorities are directed to manually approve the registration of the petitioner in the 6 Setu forthwith. On the basis of the instant order passed during the course of in the court, this court further this order passed to Mr. P. Naik, the learned counsel appearing on behalf of the respondent authorities shall intimate the respondent authorities to do the needful in that regard by due telephonic instructions. Number two, the respondent authorities are given the liberty to verify as to whether the petitioners herein have, pursuant to defects found in the school uniforms submitted, supplied, have remedied the mistakes by supplying proper uniforms as per the specifications of the then existing guidelines, and that too to the satisfaction of the school authorities, and on the basis thereof permit the petitioner to participate. Number three, this court further observes and directs that the petitioners herein shall only be entitled to participate in those schools where the tender process have not yet been completed.
Last date of submission has not, is not yet over.
That is what has been mentioned. I cannot touch
I,
that.
my understanding is that Lordship, last date is already over, but the
I mean,
process is
Mr.
not yet
Nayak,
completed.
kindly don't embarrass me, but this is a coordinate bench. Kindly have respect that one. I can't help
In that situation,
I gave
Lordship,
you all the tweaks which is necessary.
in that situation, Lordship, they will submit their bid after expiry of the last day.
That is their lookout. How they do it here, here the way have not been complete. You should have got a clarification there. But this is what it is. I can't help it. Because then Mr. B. Chetri outside only, as I said, say that this court is violating Article 14. This number, that's the plan. Yes, I was going to pass another order. Taking into account that the instant repetition, the respondents herein, next to intimation, the respondents herein are directed to bring on record their stand by filing the affidavit. When did they fix it? 27, 22, 10? 27. Okay. But on or before 17th of October 2025. Liberty given to the petitioner to submit their reply thereafter. As the instant repetition is, as the issue involved in the present petition is connected with WPC number 5168/2025 and 4987/2025. the said to repetition also be tagged along on the said date. Hello?
All item 5 to continue.
Published. The copy may not be available tomorrow is the holiday.
You'll get it now.
Lodge.
A copy of this order be furnished by the a true copy of the order be furnished by the court master of this court to the councils appearing on behalf of both the parties for due compliance.
Published.
Copies of the requisition.
Oh,
Yes,
if you
I
don't
will-
give, it became vacate.
Just now,
And Mr. Nayak with proper pagination.
yes.
Yes.
No, my lord,
No. I think now you should bring on record something
my lord.
that one thing is very clear that it is now a betterment fee.
Yes.
If it
That
is
is-
a betterment fee, it has to have a quid pro quo.
My lord.
So why are you not mentioning filing a pleading to that effect?
So that I'll do, my lord. But only one thing that I wanted to point out.
You don't point out anything. The fact that the moment I have seen it to be a betterment fee,
My lord,
why should this court at all interfere?
Because-
Taking into account that that is required. A 300 or a 400, because you see the court's jurisdiction under 226 is very limited.
my lord,
Tax is okay.
my lord.
Other aspects are very, one can very well look into. But it is absolutely the wisdom, and these financial things cannot be much looked into. So you may have a look at the judgment in this case of Jindal Steels,
My
that's a
Jindal
5 judges
Steels.
bench. But although the matter went to the Supreme Court and was again by another 9 judges, it has held that the judgment in automobile is not the proper law. But then also, you need to look into this as to how the quid pro quo element is there, because Jindal went into the aspect that it has to be exact specification.
My lord.
But that has been now by the 9 judges bench has been a bit diluted.
My lord. My lord, all these aspects, my lord, are there, but one thing that I just would like to bring to your lordship's notice. If it is, even if it is a betterment fee, and that is something that has been stated in their affidavit by bringing into, in the provision of section 266 of the Assam Municipal Act. Now, even in that case also, there is a stipulation under section 267, which was reflected on the last occasion in your lordship's order. The last order that your lordship had passed, that was, my lord, inquiring upon the aspect as to whether section 267 was complied with. Earlier, your lordship remembers, we were into section 79. Now, section 79 pertained, it was in relation to taxes. Now, it is betterment fees. Even in that case also, my lord, there is a requirement under section 267. Now, if your lordship kindly seeks section 267, publication of scheme. Before any scheme or a joint scheme for any of the purposes mentioned in section 266 is sanctioned by the state government, there should be published in the official gazette and locally the following particulars: a general description of the scheme, an estimate of the cost of carrying it out and its maintenance, source from which the cost will be met, and the amount of loan, if any, proposed to be
No,
taken.
Mr. Chakravarti, you are making a mistake out here.
My lord,
You see, the scheme is already given by the state.
my lord,
They are not asking this 300 rupees for the scheme. What they are saying is for running the scheme,
my lord.
this is required. Isn't it, Mr. Doctor?
Yes.
You see, once they have created an infrastructure by the state that, okay, we are having a good scheme out here in Silchar for giving all this good water supply to everybody, but how do they run it? For that, they are increasing the betterment fee.
Exactly. That's the position.
This is not part of the scheme, because obviously when it is the scheme, they have to inform all concerned.
My lord, page 156, the affidavit. Perhaps in my understanding, that is the scheme that they're referring to, that these are the schemes launched and adopted by the municipal board
They're not making the AI scheme.
My lord, they are adopting the scheme.
They are adopting the scheme,
My lord.
means they are now burdened out there to
My lord, my lord, my lord.
have that water supply project running.
My lord, one more aspect, my lord. Apart from this water fees or the tap charge fees, my lord, in my writ petition in paragraph number 3, I have also mentioned, and in my prayer also, I have also mentioned about the imposition of an enhancement of taxes in regard to other avenues. Now, we all along, my lord, all throughout till now, my lord, we have been into this water tax and fees, but my grievance also is scattered around this other enhancement. Now, these aspects also.
Only a judgment of the Supreme Court where the court has interfered with the rate of tax.
No, I'm not on that, my lord. Absolutely not, my lord. I am only on the compliance of section 68, because even in case of this water tax, if it is to be fees, so what the
It
other
is not
rates
a
are
water
concerned-
tax, it is actually a step, what
Yeah,
you call
that-
betterment
it's
fee.
the betterment fees, but when it comes to the other aspects, my lord, that I have highlighted in my paragraph number 3, page 11. Now, to that, my lord, if these are to be considered as taxes, there has to be a compliance under section 68. Now, in the previous affidavits, my lord, the statement that was made by the municipal board was that general assessment was made and the budgetary provision was assessed, and thereafter, my lord, there was a publication.
Mr. Chakravarti, matter has no longer an urgent matter. Earlier it was when that we were looking into the fee of 68 or not. Once it is a betterment fee,
My lord,
why should we go into those now at the time when we are approaching a vacation?
my lord,
Let the Silchar people have better water with a payment by
My lord.
better fee during the Durga Puja.
my,
And then we will consider again when the
my lord,
weather,
that can be done.
intensity of
my
the
lord,
weather subsides.
that can be done, my lord. But only thing is, my lord,
But
with-
the records I have seen it.
my lord,
What they have done is this. But Mr. There's no problem out there to bring that on record. Bring on record by putting it on record how it has become, and that budget thing. Let
Yes.
people also know. In fact, this budget and all, people should know. In fact, you have gone for publication.
Yes, yes. Your lordship is correct.
Put that on record. So let people also know how it is. Ask Mr. He also let him go and read it.
Lord,
Notice.
only thing I can say, the people of the locality has no grievance at all. There is no objection. All of them are paying the enhanced fee. But these few people, for their political agenda, they have come. It's only that, my lord, I can tell your lordships.
You see, when a writ petition has been filed indicating a grievance out there, this court has to bring it.
Yes, your lordship is very correct, my lord.
And this court, on the basis of the arguments which he is going to make, which he is making, I am not going to dismiss on the ground of entertainability or locus standi. So I'm going into the merits. So that other people paying or not, some people may be more public spirited.
That is, of course, one way of looking the thing.
And he has more faith in a
Yes,
single
yes.
bench than a division bench, and as such has not filed a PL also. See? Isn't it?
my lord, I am in troubled waters when it comes to dealing with this particular case, because my lord, what has happened, what transpired, my senior pointed out. Now, after that, it is only and only embarrassment. So, for the time being, my lord, I need to come out of this embarrassment.
Don't.
My lord,
See, when a case is being brought, this court will look into it. It merits. But the fact that the question of the tax thing being increased there's no merit on that, because it has been shown to be a betterment fee. And as regards the rate of tax which is being increased out there, yes, if it is a rate of tax which is increased which could not have been increased in view of the provisions of the Municipal Act, we'll look into that aspect. But otherwise, on the justifiability of the rate of tax?
No, I am not
Very
on that.
difficult on
Absolutely,
this.
my lord. I cannot pray before a writ court for my lord interfering into the
Okay,
rates of tax.
okay, Mr. S. Dutta, the Learned Senior Counsel, who appears on behalf of the Silchar Municipal Board pursuant to the order passed by this court
It's a corporation.
on Silchar Municipal Corporation. On the basis of the order passed by this court on 19/8/2025, has produced the records. From the perusal of the records, it revealed that there has been an increase from an amount of rupees 125, which was a betterment fee for, in the name of betterment fee, their step charge, to rupees 300 pursuant to a decision taken in the executive meeting, in the meeting of the executive body on 12/2/2025. 24, 12/2,
24-25.
24. And thereupon the budget was placed. So it is the opinion of this court that the said material can very well be brought on record by filing an affidavit, so that the said aspect can also be looked into by the counsel appearing by the petitioners. Taking into account the above, this matter on 4th of November 2025, so the affidavit be filed by 30th of October.
My lord,
The records so produced is returned.
is it necessary to record my dispute to the quid pro quo element, since I'll be bringing my pleadings also after the affidavit is filed? Disputing the fact that, my lord, though it is being projected to be fees, but we are saying that we have not been provided with any special amenities.
Mr. T. Chakravarti, I tell you one thing, that would be me entering into the arena of the lawyer.
My lord,
Which
not
not
required,
be-
not required at all, my lord. Deeply.
Item 12, fixed at 2 p.m.
Yes, what is this? Additional affidavit file, what is this?
Lordship, additional.
What is that case about?
Lordship is
PJ cycle and clients of Rita was granted a settlement of loan for the period from so and so by respondent has duly paid the fees on Iman and incident. Oh, this one happened which resulted in a fatal accident. The petitioner thereupon was issued a show cause on Iman. Appropriate action should not be taken immediately on and submitted. There was no decision taken in it. And as well, the petitioner filed another decision. On Iman, the petitioner was informed that she replied to his and the reply to the violation.
Now they have filed the affidavit, my lord, in paragraph 9. They have reiterated the stand with regard to the
They
process.
have filed an additional affidavit also.
Lordship, in the affidavit that we have filed, annexure A, Lordship, some pages are missing. That's why I have, today morning, I have paying this honorable court to bring in record the annexure A of the affidavit filed by us. The inquiry report of the district commissioner, my lord.
We will look into the inquiry report, Mr. Speaker.
So my ground basically is that the clause which they have invoked for cancellation of the, my lord, lease.
Huh?
The clause which they have invoked for cancellation of the lease. It was not, my lord, there's no, my lord, it was not mentioned in the so cause notice, my lord. So cause notice was on some different ground. I have submitted the reply.
Now they have cancelled it on the three different clauses, which doesn't have any bearing with the so cause notice at all. And that portion they have in paragraph 9 also, my lord, they have reiterated that they are under this clause number 6, 11, and 14, they have cancelled, my lord, the lease.
Now who is running that?
But they have prior to cancellation, they had suspended the lease. They have been
Now
running.
who is running it?
Department, my
Department
lord.
is running.
After the incident, my lord, we have issued so cause notice to the petitioner. He has
So his only submission is limited out here,
lordship,
that you have issued a show cause notice
lordship,
on, and thereupon he has submitted a reply.
reply.
And the reason for which you have dismissed, rejected his reply is based upon certain other charges which were not a part of the show cause notice.
No,
Right?
Yes.
no, lord.
That
It
is
was-
his
It
submission.
is submission. I will submit, my lord.
This
Tell me.
so cause notice your lordship will find,
Where is that?
page 41.
Yes. Specifically, the following serious violations have been noted. Operation in a non-marine engine boat is a clear defiance. Overcrowding the vessel far beyond the permissible, absence of life-saving equipment such as jackets, negligent operation of ferry service, endangering human. What is your reply?
Reply, my lord.
I engage my
It
marine
will
boat
ultimately come to
registered
page
by
44.
name and style of so-and-so, bearing so-and-so.
44 lordship,
Demand
clause-
for
serial number
very
7
passenger
and 8.
particular. Paid vehicle with all precautionary demand and other demand. One but such one of so-and-so had been engaged as a crew member of the hospital board. I came to know about that vehicle.
In 7, I have said it is my duty is only to collect taxes, maintain a register for the same, and submit to the local SO at the end of the month. Leti is not entrusted to the duty of inspection, the fitness or otherwise of the boat. It is the duty of the competent identity official to inspect the overall fitness of the boat
So
available.
you admit the first allegation.
Of-
Operation of a non-marine engine fitted boat.
My lord, two kind of these ferries are operating. One is the government owned, my lord, the government entrusted to us, and the other is the private that is licensed by the government. So, my lord, these fitness, everything, this rest on the the identity authority. So the boat which met the accident, as per the allegation, did not have that particular machine.
And you admit it.
My lord,
You admit it.
according
Yes,
to
yes.
them, my lord, it did not have that machine, my lord. It is
So you at paragraph 5 of your reply, page 43.
yes, the fact that Safiqul Islam suddenly changed his assigned marine engine boat, and the fact that he engaged a non-marine engine fitted boat on the date of occurrence was without the and beyond my knowledge, and as such, the owner Safiqul name never informed me about this change. So this inspection part is with the authority, they have to inspect. Not if in the meantime they have changed.
So here you have, what was the contract given to you?
To collect the tax by way of, from the passengers or the commodities, and certain other ancillary works like making of the embankment, then making the spaces, etc.
So what is the boat's, boat,
He is the lessee, my lord. He is running the Paghat. He is the lessee.
the
Boat
private?
doesn't
Yes, my
belong to
lord.
me. I am the lessee of the park, the ghat, not the owner of the boat. Two kinds of boat, as I said, my lord.
So
One
what is your duty?
to collect the taxes from the passengers and to maintain the clauses are there, I have to maintain the ghat so that person can sit and all these things, and embankment there, I have to make an approach road, that much.
Show me what is your duties of a year where some agreement must be entered into.
The agreement your lordship will find, my lord, at page 27.
Page? Got it, got it. The lessee will have to produce original letter. What is the duties of a lessee?
Clause 6, Lordship may have seen,
Where is the agreement?
page 27.
27. Okay. Formally be a power driven major. Shall be bound to cross over at any time during the day. Ferry, this is a ferry.
Yes, my lord. Ferry service.
You have ferry given.
Yes.
No, no, Madam, the ghat has been settled with
No, the lessee of this ferry shall be bound to cross over at any time during the day or night as the year. In crossing vehicles, the lessee shall not levy tolls on persons, animals, so and so by crossing by a river, not use any hire without using the approaches to the ferry. Unrecognized ferry will not, however, be allowed to play within so and so the full rates of toll. So you are running a ferry and there you are here. Then you see the following type of ferry vessels in good condition will be handed over the lessee by the executive engineer, or so it is executive engineers. It is being given to him.
Yes.
Ah,
The boat, but he has subletting the ferry ghat and he is authorized some other person to run the ferry ghat without
The ferry.
permission. Yes, my lord. This is the condition of the, if my lord is senior friend, submit senior.
okay, okay,
Yeah.
okay. No, no, this is not the Parghat and all. This is not lease.
The ferry service, my lord.
This is a ferry service.
Yes. The important clause may I
Normal
point out?
maintenance of the ferry appliances shall be done by the inland area through the authorized area, but the lessee shall be required to pay the cost of flushing oil, mobile, grease, or so and so. And Iman, and when required to do so by the executive engineers. Steamer or motor driven ferry, engine driven marboat, so and so. The ferry shall immediately after acceptance of the bid. Now, what is the ground on which it has been rejected, dismissed?
Lordship, clause
Call
15.
order. No, no, not 15, Madam. The impugn order is at page 47. Clause 6, 11 and 14.
Okay, it has been observed that clause 6, 11
and 14.
of the lease agreement. 6 is
46,
shall
11 and
bear
14 lease
expenditure
agreement,
on the
6 D of the control measure
be
ferry's rules, my
allowed
lord.
as all courts
That I have annexed.
adopted by the department for all type of the demand, the lessee shall be required to report
Very well.
due to the staff during the period. How is 6?
Lordship, it's, Lordship may kindly take up my affidavit. Lordship, we have settled the petition of the ferry service, ferry guard, my lord, and the lease has been executed as Lordship has already. And Lordship, we have in the order, the impugn order here, Lordship, we have mentioned, therefore, under authority vested upon the undersigned by clause 6, 11, 14 of the lease agreement, appendix D of the control and management of ferries rules 1968. That Lordship will find at page 69 of my affidavit. And
Oh, yes, yes. This is the actual
yes,
ferry.
my lord. Yes, this is the format actually that we have mentioned, but in his lease agreement, it is clause 15, main clause. We have mentioned in our affidavit, my lord. So annex the rule also. Page 69, annexure E. Lordship has got it, my lord.
Oh, this lease agreement has no sign of anybody. Oh, there is a sign.
It was signed, my lord.
This is.
But this is
direct.
the
Why
contract
these are
management.
both different?
Some points are different, that's why we have followed this, although points are similar, but some points are omitted in the lease agreement, so their clause number is different. So we have mentioned the clauses 6, 11, 14, that my lord may kindly have a look, what is 6, 11, 14, especially 11 and 14 is relevant in this case, my lord. Clause, page 71, my lord, clause 11. May I read, my lord?
Yeah.
The number of passengers, animals, vehicles, and weight of other things carried at one time shall not be such as to submerge the white line which marks the minimum freeboard. This line is painted by the Inland Water Transport Department on all vessels supplied by the authority or by the lessee. It is on a breadth of not less than 2 inches and runs around the marboat and single boat from stem to stem at 12 passenger distance below the level of gunwale. The steamer, motor driven ferry vessels shall be marked as per service certificate, but this ferry was overloaded, my lord. Then clause number 14, this is the important clause, my lord. The lessee shall not sublet the ferry. And his lease agreement, my lord, this clause is reflected in serial number 15. This lordship will find this 14, my lord will find page 7.
No, let us, that is okay. But that is okay, I'm not on that, but
But he has admitted.
correlate it with,
Yes.
your so-called notes.
Yes. So, of course, lordship will find at my affidavit also, I have annexed, my lord.
Here, operation of non-marine engine fitted boat is a clear defiance of the prescribed condition. As per him, the lessee shall bear the expenditure on so and so year. Lessee shall be required to deposit the entire amount that will be used. Where is the requirement out here? As per the agreement that it has to be a motorboat?
Yes, lordship, that was. Yeah. Lordship, 11, my lord,
Of his agreement,
page 74 of my affidavit, my lord.
approach road of ferry are constructed and maintained by so and so, lessee is responsible for conveying so and so. And then provide sufficient means for embarking and disembarking of via which is bound to run on one, the lessee will be responsible for all engine and plan by whole security. The steamer, motor, ferry, vessel, engine, cargo. Where is it required that it has to be a motorboat?
Lordship, that clause 11, my lord,
Where is it?
page 74 of my affidavit.
I've
my lord.
read it.
74.
The lessee will be responsible for all arrangement and appliances required to hold security. Securely, the steamer oblique motor driven ferry. Huh?
Required to hold security a steamer, motor driven ferry vessel, engine, marboat, engine, single boat to the bank when embarking and disorderly all traffic, my lord. Yes, sir.
No. I think you have to properly ascertain
And lordship, so far my.
overcrowding the vessel far beyond the permissible limit. Where is that allegation? Overcrowding is where?
Overcrowding his lordship, in
Clause,
12, my lord, clause 12. The number of passengers and.
one time shall not be such as to submerge the white line while marking the minimum freeboard. This line is painted by inland on all Iman so and so. Is the breadth of not less than so and so. Iman motor driven vessels shall be marked for survey certificate. His own expense shall provide 2 sets of. Okay. Absence of life-saving equipment. Where is it?
Life-saving equipment.
Oh, you have not prepared. How will you find?
Reply of the petitioner, lordship, may kindly have a look. He has admitted all these, my lord. He is subletting the.
Oh, no. But you see, you have to understand what Mr. Saike is submitting.
Yes.
He's submitting, look here, you have raised 4 grievances.
Yes.
1, operation of non-marine engine fitted boat. Yes, it is true. But that is not the reason for which you have cancelled. Second is overcrowding the vessel far beyond the permissible passenger weight.
Yes. This is there, my lord?
Understood.
Yes.
This is, you say out here that this is being done as per 11 or what?
This is lordship.
Where's the order?
It is 12 of the page 74 of my affidavit, my lord. Is
That's
there is
okay.
agreement?
No, but you see the termination is where?
Yes, it is.
6, 11 and 14 of appendix D of
Of the-
so and so
Yes,
lease agreement. This is, you are doing it, okay, it's a wrong marking, it should be 12.
yes, my lord.
Instead of 6, 11, it should be 12.
Yes,
Absence of life-saving equipment such as so and so. Which is there?
there is one SOP also, my lord.
No,
I haven't given.
he's referring to a specimen format, whereas the agreement executed between the parties is at page 27.
No, understood,
those-
but
those
but
clause-
Mr. Sakya, my question therefore is, unless these 4 show-cause on which you have show-cause, you were show-cause, and you may have replied, yes,
Yes.
I have made these violations. There has to be corresponding provisions in the lease agreement. Maybe not the number may not be properly mentioned.
Right.
But in the corresponding provisions in the lease agreement that these can be the reasons
Right.
which you are bound to comply. So that is what I'm asking her.
Lordship.
So that you see, if that is, she's able to produce that, that is okay. But if it is beyond that,
Right.
which is not there, or if it is on something else, which is not a part of the lease agreement,
Exactly.
and these 4 are not there in the lease agreement, because as regards subletting is not the question out here
Not-
in this particular SOCOS.
Sure.
So you cannot terminate on the basis of the subletting.
Lordship, so called it is there.
Where?
Lordship.
Page 41.
No, Lordship, my affidavit, I have also annexed.
865, your affidavit.
Yes, my lord.
Is it different?
Lordship, may I read the whole focus notice for a moment, my lord? And I have, Lordship, I have one email, one SOP that I have received recently, my lord. Lordship, may I read page 65 of my affidavit? It will clear, Lordship.
But there is a copy of the SOP for, where is the
Yes.
SOP?
SOP, I have given that.
Oh. What is this SOP? This is a
Yes.
part of your SOCOS you have not included. Hello, we'll have it after, when? Before vacation?
Before vacation. Because Lordship may kindly have a look the first point of the SOP,
Only
my
up
lord.
to the March 2000. My term is only up to March 2026.
SOP, Lordship,
And it has been
Yeah.
halted since my lord, June 2025.
there are casualties, my lord.
I have paid.
Yes.
everything.
Have you given a copy to her?
Serial number 1, 2, Lordship may kindly have. it.
Some-
Yes, possible.
I should be able to-
Okay, we take it on some other day
Lordship.
before vacation. Mr. Saike, can we take it on 16th of September, the top of the list?
But that day I have personal difficulty. I'll have personal difficulty on that day, my lord. Any day, my lord, the week commencing from 22nd, my lord.
Hmm?
If it is on 15th or my lord, it is already, my lord,
These are otherwise motion days, na?
motion days.
Lordship may pick up at two, my lord, at two on 15.
You know, you see, the problem is that on 16th, a bit I'll rise around 4 o'clock. But 18th at 3 o'clock, I'm having a division bench. It's okay.
18th.
Itna na lage more part.
Then
Because here I'll have to look into it and you have to help me out on this. You cannot come up out there and bring this. Give a copy. Have you given a copy? to
Yes,
him?
yes, ma'am.
Well, I had an occasion to see my lord once in different case, my lord, not here, my lord. But all the duties are, my lord, by the SOP has, my lord, my lord, cast on the authorities of the ITB, my lord, this department. Inland Transport. Board.
Yes, Lordship. Earlier, the petitioner boat was fitted with marine engine, but he intentionally sublet his ferry ghat to some other person. That is his reply in the SOCOS notice. This
not
boat
my
was
boat.
not fitted with marine engine. That's why this incident happened, my lord.
It is
He-
not my
he-
boat,
his,
my lord, I am
reply.
reiterating, my lord, it is
No,
not.
no. In his boat, marine engine was fitted. He has subletting the parghat to some other person, and he has stated in his reply, my lord. This is the case, my lord. He has done some negligence. So casualties happen, my lord.
It's all to save the skins of the departmental officials.
No, no, we have taken action again.
This doesn't say what measures to be taken in
Yes.
streamline and
Yes.
enhance the safety.
Lordship, his boat was initially fitted with marine engine, but he has subletted his ferry guard without any information. Subletting is not permissible as per the
But
agreement.
where is your main thing mentioned out there in the SOCOS? That is not mentioned, na? That is why I'm saying.
So, of course, hurriedly they have issued, but
You may have a very good case, but can we do so? Allow you to terminate something without that?
so, of course, Lordship. Lordship, it's their operation of a non-marine engine fitted boat.
That is
Is-
there, but where is that you have sublet?
Sublet, after inquiry, Lordship, we have coming to know, Lordship, yes.
You came to know you have put that SOCOS notice after inquiry.
SOCOS on the day of incident, we have issued the SOCOS.
On the day of the incident.
We have issued the SOCOS.
And when did you make the
The
inquiry?
district commissioner has.
So you did not give him an opportunity. That is what it is your own admission.
No, he has replied our SOCOS notice.
Understood, but whatever may be, you have taken into consideration something else which is not there in his SOCOS. He has a right to reply. Don't you think so?
That's true, but Lordship, he has made some negligence. That's why this incident occurs. There are casualties, Lordship. Students are there. Minor children are there.
So you mean to say
Without-
that a person dies somewhere, somebody kills it, you know everything, that person has killed him, then why should we do anything? Put him in the gallows.
No, no. But he has subletting the park, he has admitted.
But that's not allegation.
In
You know
the,
everything, you have not done anything.
after the inquiry, Lordship.
Till the accident, it didn't happen. Have you taken any action against that official?
Yes, Lordship, we have issued SOCOS. He has replied to us and we have forwarded to the government to take action. It is there.
Then only
We will take-
SOCOS would not help. There has to be a
We'll take action,
disciplinary
Lord.
action. Have you
Lord.
taken anything?
They will take, definitely take.
Have those persons been criminally held responsible? Because these are people who have allowed.
No, no, he
The
intends.
petitioner could not have run this through somebody else unless this executive of engineer was means without the know of the executive engineer. Very
That
much.
Lordship, that I cannot mention.
You
Lordship.
cannot say
But
the
Lordship,
junior engineer, maybe all these people knew it.
but
And
Lord,
they allowed till the accident doesn't happen, it's okay. But the moment the accident happened, now you only hold the responsible the petitioner.
no, Lordship.
Okay, you hold the responsible, but issue him a notice. That is the fair play. Don't you think so?
Lordship, Lordship,
I'm not allowing him to run,
yes.
but at least you should issue a notice to him. You found out, you see what has happened. On the date of the accident, you give a show cause.
Yes,
He gives a reply to you.
my lord.
Thereupon you hold an inquiry.
District Commissioner has,
Yes,
Deputy
you hold an
Commissioner.
inquiry. And after holding an inquiry, you come to know, oh, he has sublet. Now we terminate on the ground of sublet. But where is his reply?
He's
Where
again
has he
reply.
mentioned anything to that effect? You have seen his reply. Now, on the basis of the reply, if you want, you have to ask him. This is the procedure. That is why Mr. Saikia is here.
Lordship pays
Here
one.
is not a case that this court is going to allow him. No.
Yes.
What I can do is ask you to set aside this termination and allow you to issue a fresh show cause notice giving him due opportunity on this basis of that so that he can reply
Yes,
and take a
Lordship.
decision.
Yes, Lordship may dispose of matter in similar this ground, my lord. I have no objection. Till then, department will run the ferry service.
Yes,
Yes,
department
Lordship may
will
dispose of the
run.
matter.
But in the enquiry report also is nothing mentioned about subletting.
No, it's mentioned. It mentioned.
At least I did not see.
You think about it, madam.
Lordship may dispose.
No. I won't now.
No,
You
Lordship,
think about-
because there are casualties. My lord may dispose of the matter in the.
No,
that-
I will dispose it of. Don't worry. I'll dispose it of when?
Tuesday then, my lord.
Monday.
Monday to Lordship.
Monday too. Okay, Monday too. I'll
Then-
dispose it of.
then yes,
Because,
Dr. Varma.
Saika, you may not be there also. Then no problem. We'll dispose it of on that line,
Yes, Lord.
giving them an opportunity.
Yes, madam.
Huh? Because I don't keep CAV all this.
But Lordship, till then, Lordship departmentally will run because casualties are there.
That is your lookout. Why should I say?
Yes, madam.
You know what to do.
Yes,
So,
madam.
and give a chance to Mr. Saika to again come back.
Yes,
Even
my
this
lord.
subletting part is just because a clause exists in the agreement. So the argument.
No, now after the inquiry made, after the reply has been submitted,
Yes.
he duly admits that the marine engineering which is there,
Yes.
I don't know anything about the marine engine because it was done by somebody who was looking after it.
Looking after, he has
he-
given. We have settled the ferry service to the petitioner only.
I understand, madam. Take the benefit of his reply and put a better show cause to him.
I understand, my lord.
Yes.
Yes. Lordship may dispose of it today itself, my lord.
No, there are so many lawyers waiting. See,
Then Monday, my lord.
Monday.
At 2, my lord.
Matter having been heard, list this matter on Monday at 2 p.m. for final report.
Lordship, keep your bill, my lord.
Item 15,
Any urgency? Any urgent matters? Where there is a vacation, anything required? High Court matters can wait for some time. Review petition. Oh, this one. What do you say?
Lordship can take it up on some other day. I'm not feeling well, Madam.
Okay. At the request of Mr. D. Gusami, the matter stands adjourned to be listed after vacation. After vacation on 27th of October. Any urgent matters? Anybody has anything? No,
No, I'm not asking for only a date after that.
not you.
Item,
Any urgent matters apart from Mr. E. Ganguly?
in item
No.
28, it's a case of
Next.
illegal construction.
item 6 to
This is
11.
illegal construction and an observation of the coordinate bench that the interim order would have been considered. I'm not pressing today, a date after vacation. Item 28.
Item?
28.
Jagadish Burua. A. Hussain. Is this the matter? No, this is another.
Item 28.
Oh, this is the series, na? Who is thinking of this Jagadish? Wait,
No.
Jagadish Burua's matter? We'll have to have this after vacation, taking into account the rulemaking committee is looking into this.
By Monday,
And,
by Monday will be, I think I had a talk with the registry. The
subcommittee would have a talk with the legislative department,
yes,
isn't it?
that is, they have given, the legislative department has given the rule after the necessary correction. You will also remember.
No, that I know.
Ah.
No, then yesterday there was a subcommittee constituted.
Yes.
of Justice Midul Kolita and Justice Rajesh Mazumdar. And they are to deliberate with the legislative department. Because there are certain things which requires to
Yes.
be taken note of.
Yes.
So they will be doing before vacation, and after vacation, the matter would be, then the committee would be taking it
Yes.
up.
That'll-
We have it on 3rd of November, the 3rd, no, 6th of November.
Fine.
6th of November, by that time, we'll see what happens. But all said and done, in view of my yesterday's judgment, your writ petitions should be allowed. Yesterday, the judgment I've delivered, because I think these are some posts which are not brought within the cadre. That's your case.
No.
What is their case?
Lord, copies typist, computer typist, Renu,
Ah.
whether notification, Guwahati High Court issued notification by making equivalent copies typist and computer typist.
No, that is what I'm saying now.
They had challenged the notification.
Obviously, that is my yesterday's judgment. That
Yesterday.
how can there, by way of a equivalence, you cannot. The only way you can do is by amending the cadre. This is my judgment.
Yesterday's judgment is with regard to encadrement of the post of accountant.
Yes, that is
And
where I have
thereafter
said
we-
also that equivalence have no relevance unless the rules say so, and the rules do not say so. This is my judgment. So therefore, this petition should be allowed. But if I allow it, then what will happen? The rules, somebody has to put emphasis on the rules on the judicial side. Okay. List this matter on 6th of November 2025, taking into account that the rulemaking committee, the committee dealing with the rules are looking into the district and subordinate court rules, ministerial rules, 2025. What is the name?
Assam district and sessions are established.
No. Their name which has been given by they have given a different name.
Assam District and Subordinate Courts Employee Service Rules 2025.
Being looked into by the rulemaking committee. By the committee dealing with the rules. The registry shall update this court on the next.
Supplementary item 23.
You challenge to a gradation list.
Hmm?
Challenge to a gradation list.
See,
29/11/2020.
affidavit filed.
Pleadings are complete otherwise. Lordship, on 5/2/2025, Lordship has passed an interim order. At para 7 to 11, Lordship has discussed the entire issue.
We'll have it after vacation. List this matter after vacation on 15th of November 2025. 15 times, yeah. No.
Deeply.
24.
My lord, in this matter, I need some time to file the affidavit. It is on waiting stage, my lord.
The counsel appearing on behalf of Mr. G. Bushro appearing on behalf of the Guwahati High Court submits that some more time is required for filing the affidavit. This matter on 6th of November 2025. In the meantime, the affidavit be filed by 27th of October 2025, liberty given to the petitioner to file any reply.
26.
Yeah, I go to interim order shall continue till the next.
In this, I have filed affidavit.
Oh, yes.
Same is not on record yet, and they desire to file a rejoinder.
As an interim order, na?
There's
They
a
want to
rejoinder
regard only two trucks, Lord.
on 2 trucks.
Regard to two trucks, Lord.
Otherwise, the
Oh,
action-
2 out of
1079.
the process is over. We have kept reserved.
this is only on that aspect, na?
Under that aspect, that line, whether the tender condition eligible has been modified by the corrigenda.
Mr. Enburu appearing on behalf of the oil,
Indian Oil Corp.
Indian Oil Corporation submits that the affidavit has been filed today, yesterday. However, the same is not on record. List this matter again on, when do you want it?
On 6th of November.
Huh?
3rd or 6th of November.
3rd of November 2025. Liberty given to the petitioner to file any reply. The interim order passed earlier shall continue till the next date.
Lord.
For orders, item 13.
My pleasure, Lord.
Payment?
Payment schedule had to, my lord, because of the model code of conduct, you can impose in BTC, my lord. The petitioner is seeking that, responsibility is seeking some time to end the schedule.
This is the question of releasing of fund, Lordship.
Oh, election is there.
Election is there, on 22nd, election will be held.
This is BTC.
This BTC.
Okay, it has been submitted that on account of the BTC election, the time schedule could not be provided. BTC
This is a notification.
election scheduled to be on
22nd, my lord.
Of?
Of this month, my lord.
of September,
September.
the time schedule could not be provided. Was taking into account the above, list this matter again on 28 October 2025, on which date the respondents shall without fail provide the schedule as to how and when the amount would be paid to petitioner. Payable to the petitioner would be this.
20 October is very long, Lordship. If possible, or a short date may be given because, Lordship,
Election,
Yes,
you want to
Lordship.
come sit in the vacation bench?
the payment is, Lordship, 21, Lordship, 20, Lordship, 20.
You see, the election is till 22nd. Then the courts are closed. Obviously, they will require some time. Election is on 22nd. Results are to be announced. Then courts are closed. I'm giving it on 28th on Tuesday. Okay, I upgrade it to 27 Monday. Wait till 4 o'clock. Now, what do you want?
14.
28 or 27?
Yeah, Sir, Lordship, 21, 20, 28 and 27.
27. Yes, Mr. Das.
This is the case of.
Affidavit not filed.
No. One ad hoc been replaced by another ad
No,
hoc.
it's a long matter. Very old matter. Why it is not been filed?
But I have received the instructions, it
Huh?
says, I have received the instructions,
Ah.
it says that he was discharged because he come,
Matriculate that he
he
a
came to
matriculate
work
was engaged
in
in Malikam office cleaner by an order dated Ipan in the office while he was discharging his diligently education was discharged in that other part when he suspension made for the big copy. Oh, So
My instruction
you don't like somebody's page, you remove.
No, my instruction says, my lord, although he is was appointed as Mali, he does not do any Mali work. He used to come to the work in an inebriated condition, drinking alcohol and all those things. So they have. my
Then
lord,
file an affidavit, let him
I'll
reply.
file, I'll file an affidavit.
Mr. H.K. Das submits that he has received his instructions and he would be filing an affidavit in the instant proceeding. So taking into account the above, list this matter on 6th of November 2025.
Fine.
The affidavit be filed by 27th of October 2025. Liberty given to the petitioner to file reply if so advised.
Much obliged.
16.
May his lordship. Steps upon the newly completed, prisoner number 6 has been completed.
Hmm?
Newly
Well,
completed prisoner number
My lord,
6.
in this matter, respondent number 6 has been impleted, my lord,
Hmm.
and we have taken steps through registry, my lord. He has received the copy. But he's with me. my lord.
Okay.
But-
This is the matter. You have filed your affidavit, huh?
My lord,
Oh, this matter.
my lord.
Okay.
My lord,
Okay,
while
it has been
dictating the
submitted by
judgment, my lord,
Mr. G. Bosher, the learned counsel appearing on behalf of the petitioner that the respondent number 6 have been duly served. And in that regard, the registry has also, as informed to him by the registry, now, as would be apparent from as would be apparent from the office note dated 19/8/2025. So taking into account the service being complete, list this matter for final disposal on 13th of November 2025.
all right.
Supplementary item
the admission.
27. And connected production list item 1, 2, 3.
Production list actually.
Petition B.
Oh, that matter. Yes. What is this contempt business? Comes.
Contempt lordship, unfortunately lordship, official respondents are not there, so my brother has not served the copy lordship to obtain instruction.
My lord, contempt, yeah, well, contempt are private person, not the government official.
Intern. Okay. Now, what has happened to the contempt? Any,
Just now, just provided.
we have not provided.
No, sir, I'm sorry, lordship,
Dismiss
but
your contempt. No, no, Mr. Counsel. You are actually not serious with the contempt business. If you are filing a contempt, you have to be more
Lordship,
serious on this.
lordship, if
First,
lordship
I
comes to
don't
page,
issue notice
three
on
of my-
contempt unless we get an information.
lordship,
Now you have put it on by way of an affidavit, all these things.
lordship, if lordship comes to
Have you
page
given
three
the
of my-
additional affidavit or not?
lordship,
Have you given the additional affidavit or not?
lordship, yes, I am.
Okay.
Lordship, if lordship come to page 3 of my petition, lordship. Page 3 of my petition,
What petition?
contempt petition.
Why?
Lordship, here my contempt are private person, not the government official.
I also know
Lordship,
very well. Then also why I've asked him is that, you see, the deputy commissioner is also a party in the proceeding. So therefore, without the deputy commissioner's assistance order, he cannot run. So therefore, I've asked to make an inquiry as to whether it is actually running or not. You are asking this court to go on a finding of fact. So I'm ascertaining that. Then only I'll issue notice. I don't issue notice just for the sake of it. You file it and become a post office out here.
lordship,
Don't seem to be serious.
I'm extremely sorry.
You don't seem to be serious. Okay. Mr. So-and-so submits, Mr. K. Gogoi. This court had requested Mr. K. Gogoi to obtain instruction from the deputy commissioner as to whether the order dated 18/6/2025 passed in WPC number 3389/2025 have been complied with by an order dated 8/9/2025. This court further directed the counsel for the petitioner to serve an extra copy of the affidavit of the petitioner along with the additional affidavit so that Mr. K. Gogoi could obtain the instructions. However, the same was not furnished till date, have only been furnished today. So taking into account the above, list this matter again on 23rd of October 2025. Not 30th, 24th of October 2025. Full stop. A repetition ki khonot dibo.
The read petition, we are on interim. The interim. of
I'm
actually-
extending till that date
Lots.
because it is till today, till the next date of listing of the
Listing.
present case. So the matter has come today. So if I don't, the interim order passed in. WPC number 3389. Where is the 3389 is not come. কিন্তু মোচন আছে এইটো 3389 টো কি বুজিছো 3389 ক'ত? Yeah. Three-three-eight-nine. Three-three-eight-nine. Dated Deputy Commissioner. Three-three-eight-nine. Three-three-eight-nine not লিখিব, হা? The interim order passed
18-6.
in the instant proceeding heard Mr. So-and-so, the learned counsel for the petitioner, and Mr. K. Gogoi, the learned counsel who appears on behalf of the respondent. Respondent state. Gustav. The interim order passed on 18/6/2025 stands extended till the next date that Gustav lists the matter on
20.
এইকেইখনতো লাগিয়ে আছে আহি যাব।
Item 28.
Why so many petitions are filed? One cattle market, so many petitions. And where is PNRD a party here?
Lordship.
PNRD should come and say that all these cattle markets should be closed. Yes.
My lord. In this
What
case,
is
they-
this?
They have filed an affidavit, my lord, in this case. And
What is your case here? Submit that the respondent number 6 is constructing a building by encroaching upon the land of the.
the board has not appeared in spite of notice.
Who is appearing for respondent number 6?
Respondent number 6. We have filed affidavit in opposition yesterday, Lordship. This is not on record.
Anyways, are you constructing on his land?
We have stopped the construction of it.
You have stopped.
Stopped. Okay.
Lord,
Let
that will
us-
be recorded then. Because as per my instruction, they are still continuing playing hide and seek, my lord, in this manner. Same submission was made on the last date also, but that is the same submission was made on the last date
It
also.
will be recorded.
And that is why, my lord, the learned coordinate bench had said that I shall be at liberty to review my prayer for the interim. That's the.
Will it be proper to pass that order at court 50?
Lordship, in the
But in fact-
meantime, Lordship, we have a prayer to refer the matter to
They-
mediation, Lordship.
In their affidavit, they have expressed a desire to go for mediation. My instruction is that we are agreeable for that, but they cannot, my lord, run with the hares and hunt with the hound, my lord. They have to stop the construction. We are ready to.
Why you not, if it is your land, it's a private dispute, why you are not going before the.
No, no,
court?
I mean,
You are asking.
no,
for
my lord.
Junction
You
here.
know, it's not only a private dispute, my lord. There is no parking, there's a violation of the sanction plan. I am the next door neighbor, my lord.
So then why should we stop construction here?
But during that period, Lordship, the petitioner has got the NOC lordship to construct that with the condition that we have.
Oh, these are all questions of dispute, the questions of facts, why we are not going before the civil court.
No,
Why
no,
you
no,
converting
civil court
Lordship
is not
already has civil
no,
title
no,
deed
no,
pending
no,
before the
this
lordship.
court into a code of civil procedure.
Already has
No, no,
title deed is
because the-
pending before
municipal-
trial court test.
Now it's changing.
Pending?
Already pending,
No,
which is lost by his the younger brother of the petitioner.
then I have to argue.
Arising
that.
out of the same
No,
level.
that is regarding a tenancy for some other matter, not for this, my lord. The
I'll tell you,
the municipal board, my lord,
I have
directed stop
stated all the
construction.
thing in my affidavit, lordship.
All right, my lord, then I will file rejoinder, matter may come up for admission, my lord. If it- that
In the
is,
meantime, we have
that
a
is the
prayer,
approach-
lordship, to
that is the approach, I shall go for.
make an attempt to send the matter to mediation. We have already instruction.
I said that we are agreeable, but they must stop the work as on today, my lord, and that must be recorded. That is the only reasonable prayer. My lord. Cannot do both, my lord, mediation, and they will also continue.
have you stopped working?
Stop working.
No more
And
construction?
in the affidavit already, I have stated in my statement, lordship, that I have already stopped the construction.
In para 8, they have made that statement.
Mr. So-and-so, who appears for the respondent number 6, submits that an affidavit in opposition has been filed by the said respondent. So Mr. The learned counsel further submits that in the said affidavit in opposition so filed in the by the respondent number 6, it has been categorically mentioned that that no further construction is being carried out by the respondent number 6. However, Mr. A. Ganguly submits that the contents do not appear to be correct in as much as per his instructions, the respondent number 6 is still carrying on construction. So considering that the respondent number 6 have admitted, considering that it is the specific stand of the respondent number 6 that is no longer is not carrying out any further constructions, this court, in order that there is no further construction, directs the parties to maintain status quo in respect to construction over the land which have been disputed. Till
Look, the matter may come for
reach
admission.
the matter again on 3rd of November 2025. Liberty given to the petitioner to file the reply on or before the next date.
We have to refer the matter to mediation.
What?
Refer the matter to mediation.
Who
We
to
have-
mediation? Who has asked you not?
The
So,
petitioner is also.
why do you need the help of a mediator? You are there, he is there. Ask Mr. Ganguly, he is very good in mediating.
No, the
Attempt
one place
29.
It is he that he will be she, man.
Okay, he make it she.
Deeply afraid.
Published.
Very good. तो आपको एक ही कहीं क्यों? इस में ये क्यों कॉल है? तुम order to दिया उसे. Yes, Mr. H.K. Das, what is this?
In this case, I have received the instructions on the last. Stay order. So-
Oh, yes.
Yes, my
I
lord.
think it is high time we should approve and finish it up. But not today. You have received the instruction. Instruction were already there. Where is that?
Yes, on the
Oh,
last,
হেকিটা আগতেও আছিল।
I placed the minutes.
I returned the instructions or what? Oh, it is still there.
Yes,
There,
my lord.
there. Minutes is there.
So I'll file an affidavit if required.
At least there we can finish it up. Whether service upon that person is over or not.
Yes, sir. So far as office note is concerned,
Perhaps office note provides that
Service
service is
report has been
complete.
received from the Eastern Register which shows the notice has been duly served upon, but it is pertinent to mention that no notice was served upon respondent number 8 by the Honorable Court by the order dated here. The service report is kept on record. Respondent number 8, I have not issued notice, I suppose.
yes, Lordship, no notice was issued,
Not necessary.
not necessary,
No.
Huh?
not necessary, Lordship.
Respondent eight is all
I
right.
think respondent number 8 is proper.
Yes, Lord.
Your only case is that person could not have been.
Yes, Lord.
Yes.
That's my number 7.
It is seen that the service upon the respondent, it is seen from the office note dated 10/9/2025 that notice have been duly served upon the respondent number 7. Full stop. Mr. H.K. Das, the learned counsel appearing on behalf of the Guwahati High Court submits that he would be filing an affidavit in the matter. Full stop. List this matter on 30/10/2025 for final disposal. Affidavit be filed by 24th of October 2025.
Lordship.
It is observed that if the affidavit is not filed, the court shall dispose of the instant writ petition on the basis of the materials and more particularly annexure the document kept on record and marked with the letter X.
My lord.
Lordship, interim order passed earlier.
Interim order passed earlier shall continue till the next.
Realize this.
Much obliged.
Yeah. Matter over.
Item 18, my lord, Lordship will kindly fix after
Item?
vacation. 18, my lord,
Where is the list?
on 23rd October, my lord, if possible, my lord.
It's on good.
23rd October, my lord. Second.
Item number 18. 17?
18.
18.
Oh, 17 is over.
Done.
18 is what? What is there?
My lord, the petitioner
Matter
was,
pertains to
my lord, matter relates to my disciplinary proceeding, my lord. Disciplinary proceeding, my lord.
criminal.
Disciplinary proceeding, my lord.
Okay. Disciplinary proceeding over.
Over, my lord. Punishment has been imposed.
Punishment of
My lord, he has been reduced to the rank of peon, my lord, from the grade of process server, my lord. And my lord, his grade pay has been, my lord, fixed at the initial pay of a peon, my lord.
okay.
The allegations are serious. The allegations are taking bribe and all.
Right.
Election of
And those were found to be true.
What about 19?
19.
18,
This is
18 but you are still working.
working, my lord.
You should be happy when you are serving serious, unless you have very clear case. If you don't have a good case, then it's a very difficult thing with this type of
My
matter.
lord, perhaps Lordship would like to interfere in this case. my lord.
Okay, I am very good in interfering. Okay. This is also 2 penalties.
2 penalties.
Huh?
2 penalties.
Oh, that day we have fixed another matter on that day, na? When we should not trouble Mr. HK Das too much on one aspect. When is that? Item number 17 I fixed.
17, my lord, yes. 611, your lordship.
6/11. We'll have it on 6/11.
Well,
This is the matter on 6/11/2025.
obliged, my lord.
Affidavits filed, na?
Fine.
It is fine.
19 and 20, we'll have it on some other day. We take a date, anybody wishes.
Yes,
Because it will otherwise come before me any date.
fine.
Yes, Mr. K. Gogoi, day you come to my office once. I need some signatures from you. Yesterday, somebody gave me 2-3 books, all authored by Mr. K.
Yes,
Gogoi.
yes.
He has not given, but then also, it is always better to have the signature of the author.
Yes.